The real answer, what do I think the real answer is? There was no justice that will require the court in this condition. You can't say that the condition for yes, but then the justice that will require that you can't charge the offences.
No, I don't want to have a I'd rather do this. I'd rather
just make available these two textbooks to you.
Thank you.
Somebody can fetch it. Chief Justice and Justices, we respectfully submit that the point of departure in this matter remains the pleadings. And this court has been emphatic with regards to the obligation on parties to lucidly set out their case in their founding papers. And it is more so that one must bear in mind in this matter that we read the relief set out in the notice of motion on the basis of a case as is set out in the founding papers. And maybe just at this point it is convenient, Justice Matopu posed the question with regards to the timetable, I would call it, with regards to information becoming available to the applicant. And when you look at the record, specifically at page 011-.2-10 and onwards, this is the letter that was addressed by the Department of Home Affairs to the applicant's attorney. From the applicant's attorney to Home Affairs. Now, the 23rd of May 2023 predates the filing of any answering affidavits in this matter. The first to third respondent, which we colloquially refer to as the SAPS respondents, only filed their answering affidavit on the 26th of May. And you will remember, Justices, that in this letter, in no uncertain terms, the applicant informed Home Affairs that whilst they take note of the explanation, the full explanation they have given with regards to what transpired in Tanzania, she does not accept it. Her case is clearly set out in the founding affidavit, namely, she was surreptitiously arrested by members of the South African Police Service on 6 or 7 April. And she was held somewhere, we don't know where, she doesn't say, until the 12th, when she was informed by them, by members of the South African Police Service, and when she was blindfolded that she is going home, she's taken to the airport and put on a plane by the South African Police Service and flown back. And that, the legal conclusions following from such an abduction, obviously, as described in detail by her in the founding papers, need no elaboration. We squarely within Ibrahim. There can be no doubt about that. So that's the case that she informs all the parties. She persists with, she's not going to join Home Affairs, and she's not seeking any relief against it. We then need to look at the notice of motion, the relief in the notice of motion in context with that. And we then see that it's directed not at anybody else but the respondent cited at that stage in the proceedings. The applicant also doesn't join Home Affairs thereafter. They joined out of own accord. So at the stage when at least the first to third respondents filed their answering affidavit, this was the applicant's declared intent. This was her stance. So when the question begs, would any of the respondents have said something else had they known that the matter would morph into where we are today? Nobody can answer that question because the respondents were invited to answer to the papers based on the case that was made out in the answering affidavit, namely that SAPS, in the manner described, abducted the applicant, kept the prisoner somewhere, and then brought her back on a plane to South Africa. This is important for another reason, Justices, and that is because that version, when considered in context of the papers, is totally exclusive of reliance on a disguised extradition. It excludes it because she is quite adamant when she says there was no process wherein the Tanzanian...
Just an equitable remedy. That's what you say, correct?
No. I'm not sure.
Okay, let me read it, because then it says jurisdiction is a binary concept at paragraph 114. A court either has it or does not. The court cannot create jurisdiction through its equitable remedial powers. This has been confirmed by this court in social justice. Right. So I have a difficulty with that. Well, I might mention that I was alone in social justice coalition on the other side. But I think what you do with respect is you confuse jurisdiction at the outset and in the way in which it's used here. You urge the court to find that we have jurisdiction to entertain this application, which we must, if we're with you. No. If we follow that, then if we find that the conduct of the state parties is inconsistent with the Constitution, then surely Section 172(1)(b) gives us the jurisdiction in wide and untrammeled terms, subject only to the considerations of justice and equity. Do you accept that?
I must accept that.
Okay. If you accept that, then going back to your formulation of your three threads, the weakest and the worst amongst us, we shouldn't condone state law-breaking, and we should be careful not to yield to public opinion.
Yes.
I want to put this to you. In Cholota, this court spoke about, even though there the court had found that the extradition was unlawful, the court spoke about the need to balance lawful process with impunity, and did not find that it was appropriate for the Free State Court to find that it could not exercise its jurisdiction. Under those circumstances, this case is distinguishable from Ibrahim. In Ibrahim, Mr. Ibrahim was lawfully residing in Eswatini. He was abducted, and the High Court was asked to accept a version from the state that the police colonel was sitting in his office minding his own business, and in walks Mr. Ibrahim, who says, "I believe you might be looking for me." And the court rejected that. Here we must accept that your client was in the lawful custody of the Tanzanian authorities. Right. On what you said in response to earlier questions, there was a series of handovers. And one could say that was unlawful, but it's a far cry from an operation in the middle of the night to bring her back to South Africa.
I accept that.
Under those circumstances, how should one then balance lawful process with impunity, given that, and I accept that we don't yield to public opinion, But the public interest is a different matter. The public interest in ensuring that we have an effective system of the administration of justice. The interest involved here would be the interest of your client, but there would equally be involved the interest of state witnesses in any prosecution she might face with regard to the serious charges that she must face. And it would involve the interest of the greater South African public in ensuring that there isn't impunity. Under those circumstances, would you still insist that even if we find that the conduct of the state officials was unlawful, that a South African court should not?
Yes.
Because that wouldn't be condoning that. This court could, in the strongest terms, express its view and set its face firmly against that conduct.
Yes.
It would potentially give it a claim for damages, I don't know. But on your version, if she was to be extradited, she would have to spend time in a Tanzanian court, waiting extradition proceedings, but that's neither here nor there. So that's my question, Mr.
No, I understand the question. Let me go back to your premise of the question. I think it's quite an important dialogue that we would have. Your dissenting judgment in Social Justice Coalition disagreed with the notion of the binary concept of jurisdiction for the reasons that you articulated. And it happens to be that Mr. Perumal-Sami and I were in the Schultz-Chilotto case, but not in the Chilotto part of the case. And this court found, and it's not entirely, well, let me put it this way, it found that jurisdiction wasn't binary for the reasons that were articulated by Toronje in the context of the Chilotto extradition. In our part of the case, that issue fell away, but it didn't arise for the reasons that the court knows. But what Toronje did do for the whole court was to say that the balancing of impunity must be balanced, and she refers to Latif and Horseferry Road for this, with the notion that the administration of justice must not be brought into disrepute. And those are the words that we submit this court should focus on if the court gets to it on the basis of a disguised extradition. And the question is this, and all the cases say, Horseferry Road says it clearly, a court in South Africa should not lend its process in the context of the administration of justice when there's been the kind of conduct that we would submit is to be found here. And that's the real test. Yes, impunity is something that we all accept as a general proposition. Those who are alleged to have done criminal acts should be tried. We accept that. But not in circumstances when bringing them to court in the manner of a handover, disguised, nefarious, charade, ruse, that would bring that type of conduct, and the use of state machinery, the courts, would bring the administration of justice into. Just let me say the third thread. I think you described it as public opinion. The third thread was public opinion, but it was also this question of that's the price we pay for living in a society where the rule of law is that thread. And that's what was said in Tsebe, because Tsebe, I presume, would have received impunity because of the price that we as a society have chosen to walk a particular path, and that is a rule of law path. It's unfortunate. Nobody likes it.
Okay. But sorry, Mr. Katz, just two quick questions on that. Would you accept on the first one that this is not an Ibrahim type of case, nor is it a Chilotto case? It may be somewhere in between. And that ultimately this court must make a value judgment with regard to the agrarianness of the conduct and the degree to which it does not conform to what, and determine a just and equitable remedy on that basis. And that's within this court's wide discretion. Then, arising out of that, I think we need to be careful about the price we have to pay, because the price it's not an all or nothing. A court can equally be clear and firm about the need for the state to conform its conduct to the highest standards of legality and constitutionality. And it can do so in a manner that strikes the appropriate balance. In some cases, it may not be possible, where the court might be obliged to say, well, you should not exercise jurisdiction because the agrarianness of the conduct is such that if you do so, it will bring the system into disrepute. But we must make the call whether, in this case, that would be the outcome. And that's a call for the court to make.
It would be difficult to disagree with the ideas that Justice Collopin, you put to me. But we would suggest that although Ibrahim might be somewhat on the spectrum of the kind of egregiousness of conduct, this case is very close to it. And your Justice Collopin, you put to me,
why do you say it's close to that? Because you're saying that there was an agreement on deportation. So there was an attempt, there was at least a purported attempt to bring their conduct within the law, even if it was misguided.
No.
There was an agreement, you say.
The exact opposite. No, that agreement was unlawful in terms. It was a ruse. It was a charade. There is no agreement in deportation. And they knew. It wasn't that they didn't know. If they made a mistake, a bona fide mistake, a la Charlotta, then one would have to accept that the 172, 1B, just an equitable debate, would have some meaning, but not in a case like this. This was a ruse from start to finish. They had no power being there.
I'm not sure if the evidence supports that, but anyway, Mr. Katz, maybe we leave it at that.
Well, Justice Collopin, let me ask this question rhetorically. And this is what the minority put in the, on the paragraph that I wrote. Why did the police go there in the first instance? Where did they get the power to do it, firstly? But let's assume they had the power, a power that doesn't exist. Why were they there? They were there to achieve to find that there were people who the police wanted to prosecute. That's why they went. Start to finish. And the Tanzanians said to the South African delegation, are you going to send an extradition request? And the South Africans responded, what do you say? That's not the conduct of a state which should be able to use the machinery of the courts to do the necessary issue of prosecuting persons. The South Africans from day one behaved in a fashion which undermines the rule of law 101. And this case, we would suggest, is like Horseferry. There wasn't the Ibrahim type conduct that one's in Horseferry with Bennett, which was quoted with approval in the context of a disguised extradition. There, the House of Lords found that let's call it the collusion between the various parties, South African government, British government, rendered the conduct of the government such that the English court should not exercise jurisdiction. Very similar to here. Well, ours is worse, actually, but that's not the point. You don't have to get to Ibrahim to be able to find the no jurisdiction line, in our view.
I've heard you. Thanks, Mr. Katz. Maybe we might take different views on the matter.
Mr. Katz, I wish to direct you to certain passages in the majority judgment of the SCA. These passages talks to the pleadings. I start with, it's paragraph 16, where the SCA describe what the issues were before them. And Roman figure 1, in paragraph 16, it says, was the appellant arrested in Tanzania by members of SAPS or Tanzanian authorities? And in paragraph 21, the SCA seems to answer that question. It says, since the appellant was seeking final relief in the matter, in terms of the Pascon-Evans rules, this had to be decided on the minister's version. In other words, the minister had denied that she was arrested by members of the police. And the SCA says, this evidence shows clearly that the SAPS did not take any action against the appellant until her arrest in Lanseria. So what I want to posit there is what you had just alluded to, and when you were discussing with my brother Kolapenje. If SAPS, or what was the role, if any, of SAPS, going all the way from South Africa to Tanzania? And was it merely to escort? And if so, escort who? And if SAPS had not gone to Tanzania, does it mean that whoever or whatever, or the persons who had to go there, they couldn't do what they had to do, absence SAPS?
Just the interesting position of not knowing whether your question is one that sort of leads to a favorable decision for my client. Is it against me or for me?
I'm just exploring it. I'm just testing the
But
proposition.
I want to answer it like this, which is in our view an incorrect summation in paragraph 21, as you put it. They say that it had to be decided on the Minister of Police's version, since his evidence shows clearly that, and then there's what the evidence shows. We accept Lascon evidence. But then he says, did not take any action. That's not true. We reject that in the firmest of terms. For a policeman to stand next to a Home Affairs official or next to a High Commission official to witness, to secure the handover, is taking action in Tanzania. It can hardly be suggested that police presence in Tanzania, when somebody is handed over and the police witness the handover and they're there to protect the people who are being the recipients of the handover, that is by definition action.
Can I put it differently? If something wrong were to happen to the suspects and the police are there, would not liability arise by way of omission? Because police are there.
That would, well, I'd rather
Police are
ask,
there.
no,
Minister says police did not take any action. They were just escorting the people there.
escorting.
I'm
Yes.
putting it differently. If, for argument's sake, something different had happened and the police are there and we know the police duties to protect and they did not protect, would they not attract liability on the basis of omission?
I would have thought not. But more importantly, we would ask a different question, and this is the real question. If Bester had attacked Matthews, would the police have had any power to do anything?
That's what I've put to you. But
That's the real question. The real question is, what could they do if Bester did what was threatened, that he was a dangerous man and Mr. Matthews needed protection, so he brought the police along? It's not acceptable. It's not acceptable. It's not lawful. It's as simple as that. But that's why I say that it cannot be suggested that because no incident arose, it is suggested that they did not take any action. It just, whatever. Then it goes on, this next sentence, the version put forward on behalf of the police and others could not be said to be far-fetched or clearly untenable. The version of the police is that members of the SAPS were not involved in her arrest or her removal, but they were. They were there. They were involved. I accept that they weren't involved in her arrest necessarily, but her removal, they certainly were involved.
let's go to the pleadings, the structure of the pleadings.
The pleadings of paragraph?
The pleadings, no. We
Yes.
just get into the pleadings in broad terms. We have the notice of motion, which did not cite the sixth respondent. The notice of motion made averments, general averments, right? You would say, and the minority said, in the notice of motion, if you read the founding affidavit, allegations about disguised extraditions are there. And then you go to the replying affidavit. The replying affidavit, for lack of a better word, sought to improve what was stated in the founding, taking into account the answer. Right?
It was more focused because of the answer.
Yes. Now, that's how pleadings are supposed to be considered.
Yes.
If as the minority says, the respondents cannot claim that there is a new matter because it was foreshadowed, 1, in the founding affidavit, 2, in the reply as a result of the response in the answer. Therefore, this was consistent with the pleaded case that was before the High Court.
As pleaded. And that's the argument.
The SCA, as I understand the majority judgment, just decided the case on a narrow point.
Yeah.
To say, you did not plead. Because you did not plead, it's a new matter. And because it's a new matter, you could not expect the Department of Home Affairs or the other state respondents to respond to the new matter. They were prejudiced. Therefore, rules of the pleading says you are confined to the 4 corners of the pleadings. Absent that, you out. But the minority adopts a different view. It is that view that brought us here.
That's right.
And it is that view that I want to interrogate with you.
Well, we would say that the view of the majority, which we submit was an inappropriate view, is what really brought us here. Because if there had been 5 judges, or the other 4 judges that signed on to the minority, we might not be here. We're here because of the 4, rather than the 1. The 1 got it right, in our view, in our submission. The 4 got it wrong. And that's why we did it.
In the minority judgment, there is some reference being made to, I think it's a fallback position if I were to describe it that way, that the point about the disguised extradition may be considered to be a point of law, and if it's a point of law, and if it's foreshadowed in the pleadings, it can be raised at any time. Would that be a proper finding?
Yes,
is that a point of law?
We argue that it is, yes. We argued it in the SCA. We said that if one looks at the facts as presented, the facts, the legal consequences of those facts, that this is a disguised extradition. And it's a term of art. Even if, let me say Justice Matofo, even if the words disguised extradition had not been in the replying affidavit, it would have still been open for us to argue that this was a disguised extradition. In the same way that I know that Justice Colopin distinguishes it perhaps, but Botha versus Smith, these are terms of art, legal terms of art. If the evidence shows that the government used a deportation to achieve an extradition, that's what the evidence shows. And there's nowhere in the evidence the words disguised extradition don't appear in that form, in express terms in the pleadings. It's perfectly legitimate for us to argue this was a disguised extradition, if that's what the evidence shows, and the evidence does show it here in our submission.
I know you do a lot of these cases, but there are certain facts that troubled me, and one is the one that we've just traversed on disguised extradition. If one were to say, and the authorities in Tanzania were fully alert about how a suspect has to be transited to their country by virtue of the fact that they did ask the South African authorities, you are here, are you going to commence with your extradition processes? And the South African authorities say, no, we're not. But do people get handed over in the circumstances that the applicant and Thabo Bester
I want to answer it in 2 ways, Justice Matopo. The South Africans did not say no, we're not. They said they would be guided by what the Tanzanians agreed to. So they never said they wouldn't. If the Tanzanians had said, bring in extradition, they would have had to bring it. Number 1. Number 2, your question, which is a key question, as we understand it, is what happened here a regular deportation under Tanzanian law? Now, I know and I accept that this court cannot or shouldn't venture into the question of did a foreign government act lawfully in terms of its law in that country? Because this court is only concerned with the conduct of the South African government. And there's the doctrine of the act of state, which suggests that this South African court should not consider the validity of conduct by a foreign state in that.
Well, put it differently. Did the South African authorities act lawfully by traveling to Tanzania to collect the applicants?
Well, they didn't act lawfully in three senses. One, they didn't act lawfully in the international law sense. There's no international law provision made for that. Two, they didn't act lawfully in terms of the Constitution. Three, they didn't act lawfully in terms of any legal provision. There's no legal provision that allows for what they did that we know of. And the only one that's pointed to is Section 41. And Section 41 doesn't talk to any of this kind of conduct. So we would submit that on any level, this is the kind of unlawfulness that is staring the court in the face. But leave aside that for a moment, and that's clear. So if one talks to Justice Collipin's debate, and said, well, this was unlawfulness, they thought they could go under Section 41, but they couldn't. A Charlotta type situation. Then one could understand the debate that Justice Collipin and I were having about remedy. But this isn't one of those cases. This was collusion. It was a charade. The entire saga was in order to achieve that which could not be achieved under the immigration laws of Tanzania. And if one has regard to what the South Africans say, Tanzania relied upon Section 25(2)(c) of the Immigration Act in Tanzania, which Justice Makhoka does deal with, the minority does deal with. This isn't one of those cases. 25(2)(c) has got nothing to do with the case at hand. 25(2)(c) is a case where, but I know that this court isn't geared towards answering questions about Tanzanian immigration laws and statutes. But if the court, and Justice, the minority did consider it in some respect, but if one considers the provisions of the section which is quoted by SAPS, doesn't do what they say it does, the Tanzanian law.
Let me finish. If we look at the four corners of the appellant's pleaded case, do we find that, without attaching any label, because it looks to me that we should be careful not to be putting unnecessary labels, because if you put labels, that's where you go wrong. If substantively, on the four corners, there is a case made out that, one, there was a disguise, whatever we call it. I don't want to say deportation or extradition.
Well, an unlawful removal and handover.
Unlawful removal and handover. Then a party in the position of the respondents, one would ask, do you know what case you are to meet? If they do, are you prejudiced because no label has been attached? Absent the label, is there a case that you know that you are to meet?
Absolutely. That's the answer. That's the question. And if one looks at the founding affidavit, one looks at I've read it to the court, Pred 2 of the notice of motion, that case is square. It's there. South Africa removed the applicant from Tanzania, assisted in the removal of the applicant from Tanzania to South Africa, founding paper Pred 2. There are add-ons to that, which the court can ignore, such as the original arrest, which SAPS have given a full answer to, but not the removal. The answer to the removal is it was unlawful.
Would the fact that there was no cross-appeal be a flaw in the judgment of the majority when it dealt with it? Be a flaw, constitute a flaw?
Yes, we would suggest so. Well, that minority points it out.
Minority deals with it.
The minority says there was a flaw. Says so. And let me just say, you know, what struck me in preparing, how much unusually, and I say it was unusual in a certain sense, in the minority starts on paragraph 43 of the judgment. There are three paragraphs, 44, 45, 46, and 47, 4 paragraphs, which set out in broad summary why there was a flaw in the pleadings finding by the majority. So just 4 paragraphs as a summary. And then all the way from paragraph 48, all the way through, and it's a long, long debate, up to paragraph 68, where the minority explains in detail, thorough, considered, with reference to this court's judgments in many cases, why there was a flaw in the majority's thinking. From Barkhuizen to Pretoria Port and Cement to Justice Collipin and Justice Chaskelson AJ in Botha versus Smuts, all of the cases that this court has referred to over and over and over in the pleadings context, the minority deals with. Hanekom versus Neverkloof private game. There are many. I mean, it's too many to mention. But there is a thorough and full judgment on why the majority were flawed. If one looks at paragraph 31, there were 8 cases dealing with this question of what you put to me, Justice Matopo, about the question of prejudice. Would the respondents have framed their answer in any different way had it been pleaded differently? The answers given in 650 or 40, all through there, 52, 62, 63. And then they say, and then the important point, they even alternative, Justice Matopo. Even if the disguised extradition point constitutes a new case in reply, is it a point of law which can be advanced, even if not specifically mentioned in the papers, and the point that you make, Justice Matopo, A, if it arises from the facts, and B, no prejudice. Because there's no suggestion of prejudice. And let me go further. When it's a question of prejudice, we note a lot of talk about prejudice in the heads of argument by Home Affairs, by SAPS. But they've had every opportunity along the way to put facts which cures the prejudice.
All right. Before I step aside, I don't want to hog the space. It's a point that has been raised that the appellant, or the applicant rather, did not join the Department of Home Affairs. Is that fatal to the applicant's case?
Is it?
Is that fatal to the applicant's case?
Fatal? No, not at all. The applicant believed Home Affairs played no role in the saga. And until Home Affairs comes along and says, we did play a role, and this is the role we played. Now you've told us what role you played. Unlawful disguised extradition. How can it be fatal to the...
Is it somewhere in the papers that the applicant was aware that in Tanzania, the crew that brought her, I don't want to say arrest, because arrest is the problem now. The crew that brought her back to South Africa included officials from the Home Affairs?
No, she didn't know. She only knew because of what he said in the answering affidavit.
She thought these were police officers.
That's what she said. That's what she said. I think she also at some point thought that there could be defense. She didn't know.
Sorry, I missed that.
There was some point, if I remember correctly, where there was a mention that it could have been SANDF.
Oh yes.
But it's irrelevant. She didn't believe that Home Affairs were part of part of the crew. It turns out they were part of the crew. They were the dominant feature in the crew. And bearing that in mind, they were joined. They filed an answering affidavit. There was a reply. And in the reply...
Just help me with the order. I know there was a request for information. Did it come before the papers were drawn or...
Before.
Before the papers were drawn. And that request was declined?
It was suggested that the applicant makes use of PIA. That was suggested. One sees that, pages 32 and following, where the attorney wrote to say, a client is pending trial, a client was arrested, we hold instructions to demand the following, the process and procedures, and then the state attorney writes back to say, well, I'm not sure it's the state attorney, but there's a write back from the DPP on page 37. I'm directed by the DPP to acknowledge receipt of the request. And then it says, despite the undermentioned unclarity, she was arrested at Tanzania, and any further information must be sought through PIA.
Thank you.
Mr. Katz, I just want to concentrate for the moment on what Tanzania as a state did in this case. Your client was illegally in Tanzania. Those are the facts.
Yes.
On the 12th of April 2023, the Tanzanian authorities issued a notice to prohibit immigrant.
Yes.
And that was a notice for which provision was made under domestic Tanzanian legislation.
Yes.
And the order in that notice was that your client depart within 3 days' time under escort.
Yes.
Under escort typically means compelled.
I accept that.
I'm not aware of any international law that says that a deportation under escort can only occur where the person has resisted deportation.
We don't know of any either, no.
So Tanzania could lawfully have taken the view, with or without South Africa, that she was to be deported under escort.
One accepts that.
She was a South African national.
Sure.
She had said, so it seems, that if she was to go anywhere, she wanted to go back to South Africa. And I mention this not as a waiver of any rights she might have in relation to extradition, but as to the significance that might have to Tanzanian authorities as to where she should be escorted.
I understand the question.
Now, on those facts, can we find that Tanzania did not, under its law, lawfully perform or make a unilateral decision that this lady was to be escorted out of the country and put on that aeroplane?
I have two responses, Justice Rogers.
And bearing in mind, I think it was the Canadian case or one of the cases that said the fact that that might be very welcome to the South African authorities is neither here nor there, if that is what they were doing. And perhaps you can also let me know whether there was any other country to which she could lawfully have gone at that time.
Justice Rogers, in order to enter into that debate, which I don't believe is an appropriate segue, one would have to look at what the South Africans say about what Tanzania did. That you can't get it because Tanzania are not here. And what the South Africans say Tanzania did is they say to the South Africans, are you bringing an extradition request? That triggered the saga, the steps of facts. And
yes.
then...
So I suppose that the Tanzanian response, if South Africa says, well, that depends on what you, Tanzania, are going to do, then Tanzania says, well, we will have her deported under escort.
Yes.
Then South Africa says, that's fine, then we don't need to bring an extradition application.
Then one looks at on what basis did Tanzania do what it did. You have to look at the basis if you're going to go down that road.
I would have thought the basis of what it did is self-evident from the common cause facts which you've accepted. She's a South African national. She is in Tanzania unlawfully and has expressed the wish that if she is to leave, she should go back to South Africa. What could be more natural?
Where's the law that allows for that to have happened? There one finds on page 109. This is not our version. This is the government's version. They say, and they say it in terms, Shabiri says it, he says, the Tanzanians acted lawfully because they utilized section 25(2)(c) of the Tanzanian Immigration Act. That's what they say. And if it turns out, which if the court's going to go down that road, then the court has to consider, does 25(2)(c) of the immigration law of Tanzania allow for what happened to happen? And we say clearly not. If the court goes down that route.
Well, your case requires us to find that Tanzania didn't do what I've just said they did. It requires us to find that Tanzania, along with South Africa, was going through a charade.
Yes.
Well, let me not say more about that. Just on the notion of a removal or deportation under escort, the fact that it doesn't have to be confined to cases where the person is otherwise unwilling to leave. You will recall that South Africa very recently deported under escort
Mr. Mugabe Jr. back to Zimbabwe, which is exactly where Mr. Mugabe Jr. wanted to go. But I suppose the point is the deporting state, by deporting under escort, makes sure that the person actually leaves.
Yes, that's all.
And at least on one construction of the facts, and the one that doesn't require us to find that Tanzania was going through a charade and acting duplicitously, is that having decided that she must leave the country, and that South Africa was the natural country to which she should go, they then find that South Africa, what do you say? And South Africa says, we're happy to take her back.
But then,
now, on Plascon Evans, I must say I battle to see on what basis we can reject that construction of the facts, rather than the view that these two states were both acting duplicitously.
Well, this court can't, we would suggest that this court doesn't need to find that the Tanzanians acted duplicitously in the sense that I've suggested. What I do say is that the South Africans acted by way of a charade, for the reason that I articulate. But may I turn to 25.2c?
So you say the South Africans acted as a charade, but take the case, the Canadian case, where the country that would like to prosecute the fugitive greatly welcomes the other state's decision to deport. Now, you can't infer from that that there is collusion. All you can say is that the deportation, which is, if I may say, the most natural thing in the world for Tanzania to have done, happens to save South Africa the trouble of applying for extradition. After all, this is not an unlawful or forced extradition where the person is in a country where they are entitled to be, as I think was Mr. Ibrahim's case. He was entitled to be in Swaziland.
Accept that.
Here, it is common cause that Tanzania was entitled to deport this lady. They had found her, not South Africa. And I just don't see why the fact that the deportation was welcome to South Africa, and at least on some evidence to Ms. Magudumana herself, should convert a legitimate deportation into a disguised extradition, in which it can only be a disguised extradition if you tarnish Tanzania with the same brush as South Africa. There can't be a one-sided disguised extradition, because, as you say, extradition is a bilateral act.
Well, then I have to turn to page 109 of the pleadings, 011.1-109. This is what the government rely on for the notion that, Justice Rogers, you put to me this was a lawful deportation. Because 101.9 reflects section 25. And there are two subsections, 25.1 and 25.2. And what the South African government put up is that the Tanzanians relied on 25.2c of their act. And 25.2c, it's in our submission, makes it plain that that isn't a section which allows for a, let's call it a prohibited immigrant, an illegal foreigner, to be dealt with the way the applicant was dealt with. What 25.2c talks to...
Remind me, what does 25.2c say?
It's on page 110.
Sorry, I'm not following the case lines record. Do you have the hard copy record?
It's hard copy 110.
110?
Of the pleadings. What happened in... Do you have it?
Yes, I have it.
So 25.2 says, any person arrested under provisions of 1, and let's accept that she was arrested under 1 because she was a prohibited immigrant, shall, without delay, brought before a magistrate, and she wasn't. It's common cause that she was not. And there are 3 exceptions to that. And the South African government rely on the 3rd exception as to why she wasn't brought to a magistrate within the time. This goes to this question of the collusion and the disguised extradition. A and B are irrelevant for our purposes, but C is the section that they rely on. Where such person has been declared a prohibited immigrant in Tanzania, which happened, so there's the jurisdictional fact, he may, instead of being brought before a magistrate, which happened, be placed in custody, which happened, until he boards a ship or aircraft or obtains any other means of transport conveying him to any place outside. So the idea is that the way we read it, the 25(2)(c) says that the person doesn't have to go before a magistrate if the person voluntarily leaves and by way of a ship, aircraft, or obtains any other means of transport. So the whole idea is a prohibited immigrant always goes before a magistrate, unless the prohibited immigrant stays in custody and obtains a ship, plane, or other means of transport illegally.
Well, I'm not sure this court should get embroiled in interpreting the Tanzanian Act, but it's until she boards a ship or aircraft, which is what she did, or obtains another means of transport. So the obtains doesn't necessarily apply to boarding the aircraft. But again, we come back to the evidence that the evidence was not that in her capacity as a deportee, she didn't want to be returned to South Africa.
That goes to the question of consent.
No. You raised the question of consent as a... sorry. The argument about consent in the written submissions is about waiving rights in respect of an extradition. Here I'm talking about viewed unilaterally from Tanzania's perspective as a deporting state. If she was willing to go back to South Africa and she boards an aeroplane, why not? Under Escort. It's the place that she has expressed a desire to return to, and it's the obvious place for her to return to.
Yes, there's a whole range of difficulties.
But either way, that gets into an interpretation of the Tanzanian legislation. I'm not sure it's going to be productive to debate.
That's the point.
But if ultimately the case is going to turn on whether 25(2)(c) of the Tanzanian legislation strictly applied, that might imply that Tanzania shouldn't have allowed her to be placed on an aeroplane, but should have brought her before a magistrate.
Or some other method. There could be some other process that could have been followed.
It doesn't mean that there wasn't a genuine Tanzanian deportation. It just means that Tanzania might have not crossed all the T's and dotted all the I's.
Because they wanted to assist South Africa in South Africa's desire to prosecute this particular individual. And she couldn't go to Canada, or she couldn't board a ship or plane or other means of transport out to any place outside Tanzania. That's the real issue. Tanzania wanted to make sure that the South African desires were met. And one of the things that struck me in reading these papers is when the police say, and Home Affairs confirm, that the kinds of, let's call it avoidance tactics, that they use. So, for example, they say...
Sorry, I don't want to waste too much time. Is this an answer to my question?
Well, it goes to the... Justice Rogers, if I understand your question, you ask me, is what Tanzania did in the big picture, from a flavor perspective, such that it can be criticized as inappropriate as part of a disguised extradition?
My proposition was that if in all other respects Tanzania was plainly following a deportation process, the fact that on one interpretation of Section 25(2)(c) of the domestic Tanzanian statute, it shouldn't have followed this route, but should first have taken the applicant to before a magistrate, well then it acted incorrectly under its own law.
I've said my point was, if we go down that route, then we've got those difficulties to confront. I accept that. But the point that I wanted to answer to Justice Rogers is this, that if one looks at, for example, in the paginated pages 54, case lines, both 54, paragraph 48. 48. So 54. 54. The 44, 45, and 46 are what we would suggest, and the minority found in the essay problematic. On 8 April, SAPS received information. According to the information, Beston was, etc. Then 45, it was important to confirm that it was indeed them. Thus, the arrest had to be confirmed, and the identity of the person had been arrested had to be confirmed as being them. Then the important sections for purposes of this portion. 46. An urgent meeting was arranged by SAPS in Tshwane, to which meeting Interpol was invited. At the meeting, a decision was made that a multi-department team from SA should be assembled to travel to deal with the matter. What matter? It's no matter. The only question was the identity of the two at that point. This is on the 8th. In 47, a delegation consisting of 8 members. So it's...
Mr. Katz, I'm aware of the facts.
Yes, yes.
It is clear that if Tanzania, on one construction of the facts, if Tanzania was wanting to deport South Africa, including the police, would be very keen to have her back.
And the question that the court will... But the problem, Justice Rogers, is a very simple one. It's what I started my address this morning. The decision was based on an agreement to deport. That's the problem. So Tanzania itself, on the common cause facts, entered into an agreement with South Africa to deport. And that's problematic. No matter, however we cast it, whether Tanzania were entitled to do so, whether it was their desire, etc., whether they're lawfully entitled to it, whether they did it lawfully or otherwise, they entered into an agreement to deport. It's how I started this morning. Which we submit is wherever there is an agreement, and we cannot get away from the words we suggest, an agreement to deport. So it wasn't a unilateral decision to deport. Justice Rogers, all your questions, we would suggest, are framed in the context of a unilateral decision to deport, which they may have been entitled to do.
Well, there may have been a unilateral decision, but that she should be deported under escort. And once one gets into the element of escort, you're into the element of a compelled return or a compelled deportation. And I understood from your learned colleague's argument on that part of the case that it's in that context that implementation may involve agreement between states.
The difficulty is this.
I think I've taken up enough time.
Just one last point. I just want to make this point. The agreement to deport was entered into before the decision or the notice of escort. So the agreement to deport was taken, and thereafter was the notice which included the escort item.
That may be relevant. Direct me to the evidence on that.
The relevance is...
The notice to deport was dated on the 12th of April,
12th?
Which is the date on which, according to my evidence, the police met in, the multi... met in Pretoria and decided to travel.
It's the evidence of Ms. Mangaung, which is in volume 2, in paragraph 13 on page 182 of the hard copy. One sees on paragraph 10, it says on 8 April 2023, there was the information provided. Then on 9 April 2023, the commissioner met. They had a meeting. That 9 April meeting predates the escort notice.
So that's the High Commission meeting?
Yes. And then if one turns to the next page, paragraph 13, it says the agreement, and the only place that there could have been, at any time that there could have been an agreement, as we understand the pleadings properly interpreted, was on the 9th of April.
Yes, but at that stage, the police don't know about it in South Africa.
They do.
I understood that it was on the 12th of April that they learnt of this.
No, paragraph 44 on page 54, on the 8th they received.
Sorry, let me just write down these references because I...
So on page 54, paragraph 44, the police hear about the issue on the 8th of April, and they have an urgent meeting. In 47, the 8 members go, and they boarded the plane on the 9th. The police only had their meeting at a later time, because it was Easter Saturday or something. But the evidence from the High Commission is that the meeting took place on the 8th of April. That's paragraph 10.
Thank you.
So we would suggest the decision, well, once there was an agreement prior to the escort, that's the end of the case on the question of disguised extradition.
Thank you, Mr. Katz. I'm interested in the Canadian case of Kindler, federal court in Canada, in which the court expressed the view that where there's a special procedure for the surrender of nationals, then a general, such as an extradition procedure, then a general power to deport cannot be used to replace it. So it seems to me that in extraditions, what one's trying to ensure is that the safeguards are kept in place. And, you know, those safeguards we know well. They are to ensure that the crime is recognized in both jurisdictions, that you're not extraditing for political offences, that, for instance, human rights are adequately protected, the issues around which this Court's dealt with in the past around death penalty assurances, and also the prosecution for the same crimes. So my concern really turns on whether this sort of an agreed procedure to come and fetch on a deportee really doesn't undermine what the extradition procedure is aimed at. And so where does it begin and end when one's trying to, when one state contacts another and says, we're deporting X, come and fetch X, why is that not necessarily bypassing an extradition procedure?
Yes. Well, Justice Savage, just to add to the difficulty in this case, South Africa and Tanzania are parties to an extant extradition agreement, the SADC Protocol on Extradition. So there is an extradition mechanism available on the international plane for the kinds of issues that we say should have occurred, quite apart from whatever Tanzanians' domestic extradition laws might provide for. That's number one. Number two, in Muhammad, if the way I read Muhammad, the particular paragraph where it talks about the bilateral and unilateral distinction, they say, this court says, in practice there may be a coincidence of the effect of what happens, as you put it to me, Justice Savage, and the court will decide on a fact-by-fact basis as to whether the particular coincidence, in borrowing from Justice Rogers' debate, amounts to disguised extradition. And we say on these facts, we come home on that basis. That's fact-based. And we look at the facts. I've just pointed out that there was an agreement reached to deport.
Isn't one of the facts also that South Africa had an interest in this deportation because it wanted to prosecute?
Absolutely. And that's what the minority, I've read the paragraph, I don't want to read it again. The original police delegation which went on the 9th and the 10th, it went there with that in mind. There were 8 members. To my mind, there were 8 members, and if one looks at the identity of the 8 members of the police, it's telling. And this is what the minority spoke of. The 8, let me just find it. The 8 started off with the person who deposed to the affidavit. That's paragraph 47.1 on page 55. And he describes himself in the answering affidavit as a male brigadier. So one has a brigadier, we have a Lieutenant General Mosikil, we have a General Modisi, we have another general, 3 generals, a brigadier, a colonel from Interpol, an immigration official, and somebody from DSC. And then we submit, incredibly, somebody from the DPP's office. Somebody from the DPP's office went as part of a delegation to Tanzania to see, and if we see what the purpose of the meeting was on paragraph 46 on page 54, it was the people were assembled to travel to Tanzania, and these are the key words, to deal with the matter. And that's what the minority says. It's clear from day one. The entire project, the saga, was there for one purpose and one purpose only, to prosecute. That's what he said. One can't get away from these facts.
Mr. Katz, my next question relates to remedy, and particularly the case, or the House of Lords case of Shahzad, in which the House of Lords introduced a balancing exercise, noting that the decision whether to stay criminal proceedings on grounds of abuse of process constitutes an exercise of judicial discretion that requires judges to weigh countervailing considerations of policy and justice. And I'd just like to hear your view on that in relation to this matter. And I say so because if you were to translate these facts into quite a different kettle of fish, for instance, if one had in these circumstances, for instance, a serial killer who was then returned to South Africa, would countervailing considerations of policy and justice not then align more favourably towards continuing with the prosecution?
Yes, that's a good thing. Justice Savage, I think that's what we would suggest is the real difficulty that the court is faced with in this case overall. We would submit that there can be no difficulty on any level in finding that this was a disguised extradition. That's our submission on the facts. The question then arises from your question and Justice Colopin's question of, are these facts appropriate for a stay? And we're not even sure that a stay is the right concept, but look at paragraph 116 of the minority decision in the SCA. But what we submit is this: you don't have to go to the House of Lords. You can go to Chiloto, where Justice Turon, I think it's paragraph 164, says that this court in this case, will have to balance impunity with the question of bringing the administration of justice into disrepute. That's the balance. And you strike that balance through the facts. And we submit on these facts, where we have an agreement to deport entered into before the escort notice, the court can only come to one conclusion: that this was a charade, it was collusion, and this court will not allow for criminal courts. Let's call it, it's a very valuable resource in this country. That valuable resource should not be used in circumstances when those who are tasked with bringing accused to court, prosecuting accused persons, behave in a fashion that we would suggest is unlawful, unconstitutional, and a violation of international law.
Thank you.
Mr. Katz, just help me to understand why you say that the agreement was reached prior to the applicant being declared a prohibited immigrant. Because my reading of those paragraphs doesn't suggest that the meeting with the Tanzanian counterparts occurred on the 9th.
The paragraph 13.
I will read from paragraph 10 because it seems to be narrating how the events occurred.
Yes.
Paragraph 10, the information is received. On the 9th, there is a meeting. It's not clear whether the Tanzanian counterparts were at that meeting. Then the events further are then relating to the 11th and then the 12th. And then thereafter, there's reference to the agreement.
The paragraph 13?
Yes.
Yes. If one reads paragraph 13, we would suggest contextually, it could only mean that that agreement, referenced in paragraph 13, occurred in respect of the meeting that is described in paragraph 9. There's no other time that it could have happened. And if one reads paragraph 13 as a whole,
Paragraph 10, because the meeting is referred to in paragraph 10.
Paragraph 10, that's correct.
But my question is this, that it's not clear in that meeting if it was a meeting of the South African people only. Or
well, if one looks at paragraph 13, it says that agreement between the authorities to deport, then the words are, was reached at the premises of the High Commission. And there was only one meeting at the premises of the High Commission. That's the meeting described in paragraph 10. There was no other meeting. There were other meetings at the hotel with the SAPS delegation. That's the later meeting. But this meeting, the meeting where the agreement was reached at the premises of the High Commission, was the meeting described in paragraph 10 on the 9th of April. There's no other meeting.
For that. And then lastly, on the remedy, you seek the remedy that is referred to in paragraph 2.1 of the minority judgment.
Yes.
The first part of which declares the handover by Tanzanian authorities to South African officials as unlawful. Now, on what basis?
So I've lost you. So paragraph 1 is, it is declared the handover was unlawful.
Yes. On what basis should that handover be declared unlawful? Where there does not seem to be anything that is directed at impugning the conduct by the Tanzanian authorities.
No, because what we say is the receipt by Marong and the handover from Marong, I think that's how you pronounce it, to Matthews, that was unlawful.
No, I'm now focused in the first part, which seeks to declare the handover by the Tanzanian authorities.
Yes. No, I understand. But the handover was unlawful in our submission from the perspective that the Tanzanian authorities might have, from their perspective, done a lawful handover.
Then how do it, sorry to interrupt you, if we say they might have acted lawfully by handing her over, then how do we declare that?
No, because I'm making this point.
Okay.
No, what I would say is I don't know what we don't know, and I've had the debate with Justice Rogers about 25(2)(c), which we submit is problematic for the government. But leave aside that for a moment. What we say is, from a wrong to have received the people was unlawful. So perhaps, if this court feels that 172(1)(b) allows, you could change the words from handover to receipt. But we would say it's 6 of one and half of the other. The handover was unlawful to the extent that Morong received the person. That's the issue.
Take the T adjournment until 12:15.
Thank you. Thank you.
Mr. Snellenberg.
Thank you, Chief Justice. Mr. Katz asked me to just make available these two textbooks to you.
Thank you.
Somebody can fetch it. Chief Justice and Justices, we respectfully submit that the point of departure in this matter remains the pleadings. And this court has been emphatic with regards to the obligation on parties to lucidly set out their case in their founding papers. And it is more so that one must bear in mind in this matter that we read the relief set out in the notice of motion on the basis of a case as is set out in the founding papers. And maybe just at this point it is convenient, Justice Matopu posed the question with regards to the timetable, I would call it, with regards to information becoming available to the applicant. And when you look at the record, specifically at page 011-.2-10 and onwards, this is the letter that was addressed by the Department of Home Affairs to the applicant's attorney. From the applicant's attorney to Home Affairs. Now, the 23rd of May 2023 predates the filing of any answering affidavits in this matter. The first to third respondent, which we colloquially refer to as the SAPS respondents, only filed their answering affidavit on the 26th of May. And you will remember, Justices, that in this letter, in no uncertain terms, the applicant informed Home Affairs that whilst they take note of the explanation, the full explanation they have given with regards to what transpired in Tanzania, she does not accept it. Her case is clear, clearly set out in the founding affidavit, namely, she was surreptitiously arrested by members of the South African Police Service on 6 or 7 April, and she was held somewhere, we don't know where, she doesn't say, until the 12th, when she was informed by them, by members of the South African Police Service, and when she was blindfolded that she is going home, she's taken to the airport and put on a plane by the South African Police Service and flown back. And that, the legal conclusions following from such an abduction, obviously, as described in detail by her in the founding papers, need no elaboration. We squarely within Ibrahim. There can be no doubt about that. So that's the case that she informs all the parties. She persists with. She's not going to join Home Affairs, and she's not seeking any relief against you. We then need to look at the notice of motion, the relief in the notice of motion in context with that. And we then see that it's directed not at anybody else but the respondent cited at that stage in the proceedings. The applicant also doesn't join Home Affairs thereafter. They joined out of own accord. So at the stage when at least the first to third respondents filed their answering affidavit, this was the applicant's declared intent. This was her stance. So when the question begs, would any of the respondents have said something else had they known that the matter would morph into where we are today? Nobody can answer that question because the respondents were invited to answer to the papers based on the case that was made out in the answering affidavit, namely that SAPS, in the manner described, abducted the applicant, kept the prisoner somewhere, and then brought her back on a plane to South Africa. This is important for another reason, Justices, and that is because that version, when considered in context of the papers, is totally exclusive of reliance on a disguised extradition. It excludes it because she is quite adamant when she says there was no process wherein the Tanzanian authorities were involved. I was brought to South Africa solely as a result of the actions of the South African Police Service. So the one is exclusive of the other. The case that was made in the founding papers with respect, and the case that the applicant seeks today, cannot be married at all when one follows a sequence. The second point, which we respectfully submit needs some emphasis, is that at no juncture did the applicant amend the relief. In the Supreme Court of Appeal, there was in the heads, there was a notice that they would seek relief against Home Affairs and would ask for a change of relief, but there was no attempt to formally amend the pleading, and a notice of motion is a pleading. Whilst relying today on the fact that at the conclusion in the replying affidavit certain prayers or relief was set out, it was never sought to be amended in the High Court as well. And this court specifically has been very astute to lay down the rule that no matter what we're working with, there are certain basic rules we must follow. And one of them is that it is in rare, exceptional cases where this court would amend relief that the applicant never sought. Yes, she was represented. She had representation already in Tanzania, we now know. She was represented in these proceedings throughout. And she never saw the need to amend the relief, and now today says, well, she finds favour with the relief that the minority in the SCA said they would have given. So when one considers it and approaches the matter from that point of view, then there's very little room, if not none, to find that the disguised extradition argument was canvassed in the founding papers, and all that the respondents would not have been prejudiced in a manner that it was introduced or sought to be introduced, because the applicant here made her stance very, very clear throughout. But importantly, before the respondents filed their papers. In the High Court, and in the SCA, from the first to third respondents' position, Section 171B was raised, and the binary concept was used to say, well, that the court can't consider, if it does make an order in terms of 172(1)A, that's it. We respectfully submit that it doesn't need debate. The answer lies in Section 172(1), which says when the court makes an order in terms of A, the court is entitled to make a court order in terms of B, and that's not prescribed for a reason. And this court adds, we respectfully submit, in the Schultz-Charlotta matter, already established that in matters of this ilk, that also follows, that also applies. There's no ousting of it, and we respectfully understand this court to say that one should be astute. It's not any irregularity in a process won't necessarily result in the criminal court being divested of jurisdiction. And I think Justice Gulab and Justice Savage raised the public interest point in this matter, which brings me back to the start, and that is one should be careful not to divorce the clinical arguments in court from what we know the background to have been at the stage when all this started, because it explains the multi-department team, if I might call it that was constituted. Mr. Bester, the convicted murderer and rapist, escaped. And information was received that he was arrested with 2 other persons in Tanzania. We now know the applicant was one of them, and we know that a non-South African resident was the other one. That is the information that caused them to put together this team, to travel to Tanzania. Now, it's one thing, with respect, in retrospect, to be critical, but Pascal Evans teaches us that in order to find in the applicant's favour, you must reject the respondent's version as palpably untrue or far-fetched, and that is not the finding that the minority makes. The minority says in the SCA that he doesn't find that explanations convincing. We respectfully submit that there is no basis, and we say this with a lot of respect, for that. If one considers that this was a public interest matter, the sending of a team to Tanzania at that stage was not, I think they say also in the affidavits, wasn't something new or something funny. And one can't read into that, with respect, the mere fact that this team went, that there is a collusive effort or there would be collusion. Because if one reads the affidavit that my learned colleague quoted to you, if one reads those paragraphs from paragraph 8, you don't just start at paragraph 13. And it's quite clear, and the High Court actually dealt with that, that the meeting that was referred to wasn't a meeting at that stage between South Africa and Tanzania. So if that is the basis for the reliance on the collusive dealings, then we respectfully submit that the basis isn't correct, not on a proper reading of that portion of the papers. So, a convicted murderer and rapist had to be brought back. We now know when the second plane goes, that is what will happen. Why would it be untoward or suspicious for police service members to be on that plane? Because this person must come back to South Africa. And he's now with officials. Why wouldn't the police it would be totally in order for the police to be on that flight? It is both the minority and the majority accepted that the South African police services did not arrest the applicant in Tanzania, that the applicant didn't take issue with that finding. So the mere fact that they are there, but merely spectators, says Home Affairs, doesn't elevate their conduct to anything else with respect on the papers, objectively read. So, by extension, the applicant's case, firstly, as she made in the papers, couldn't pass Plascon Evans, and secondly, even on this aspect, the first to third respondent didn't have anything really to answer, because they did nothing. And she hasn't established on the papers that they did anything wrong. Chief Justice, you're welcome to. That is our opening statement.
Thank you, Mr. Snellenberg. You are saying that there was no amendment in the papers of the applicant.
Yes.
The new matter that you say the applicant introduced in the matter, was that not from the answering affidavits of the respondent?
They say so, but I repeat, the answering affidavits was crafted knowing that the applicant said, I am only interested in South African police services. You abducted me as I described in my founding papers. I'm not joining Home Affairs, I'm not asking relief against them because I don't accept what they say. That is not my case. You know what my case is.
But didn't she, in her reply, introduce some of the evidence that was in the answering affidavits?
Obviously she did.
Was she entitled to do so in her reply?
No, because she now made a new case.
No, but if she's relying on evidence that has transpired through your answer, is that improper pleading?
Yes, Justice, she should have been. I think the SCA majority was correct. In those circumstances, you you style your affidavit as a supplementary founding affidavit, becomes part of a basis of your case, more so where you have developed any intent to rely on that information.
If you make an application on broad allegations in your founding affidavit that what I was subjected to was unlawful, and you only know or you assume that it was South African police, and then in the answer you gain knowledge that it was not just South African police,
That's the point.
and you get the information there, can't you then incorporate that information in your reply?
Yes,
Because you're still saying that the action was unlawful, but then now you've got more information on why it was unlawful and who are the participants. But you're not changing your case that, in fact, what happened to me was unlawful, but you're giving it more information now.
This is in principle. In other matters, that might be quite correct. But this isn't the fact here. The applicant didn't come to court and say, look, I don't know what has happened. I was abducted from Tanzania. I don't know by whom. I don't know who did what. She was quite explicit with regards to what happened. After and that's why I started with the letter from DH8, because that's before any answering affidavits are filed. They say to her what they explain to her how things transpired according to them, and she says, I don't accept that. My case is that the South African Police Services abducted me. She also you'll recall, Justice, she named names of two of the police officials, which she says was part and parcel of that. So this isn't a matter, as you described, that from time to time happens. You receive an answering affidavit and you then reply. The new matter is by means of a reply to what was stated in the affidavit. This is totally different.
No, I'm asking that because my reading of her paragraph 8 in the founding affidavit, she does say that she was abducted or arrested or forcefully abducted by members of the second respondent.
Yes.
But then she then says that I do not know the members of the South African Police Service. I can confirm that I was taken to the airport in Tanzania by members of the South African Police Service.
Yes. That's what
Here she is not claiming to know exactly the details of the people who accosted her.
Yes, but remember, Justice, that's correct, but when you read this in context, she is sure it's members of the South African Police Service. She says she doesn't know who they are, what their names are. She later says, I know two of them that took me on the 12th to the airport.
Personally, I just think that I understand why she would give the court what she knows at that moment, and when more information comes to her arising from the answer, why she then used that information to sort of, not to amplify her case, because her case is the same. I was taken from that country unlawfully, and then she gives more information because she got that from the answering affidavit. But let's move on from that. You said that she was not supposed to have done it. What I'm also interested in is actually what the South African team went to Tanzania to do when you went, not really what actually happened there. We're going to get to that, but my interest is what was the intention of going to Tanzania? Was it to assist in the deportation or to have an extradition process?
When that first team went, they went after they received the information to Tanzania, obviously to go and gather information. What they say is in the papers, sorry, Justice, what they say in the papers is that in their minds there would have need to be certain things, verifying that Mr. Mr. Bester was one of them. I know that the minority was criticism to that, but the fact of the matter is at that stage, they also say, during that first meeting, Tanzania was informed that you do what you do and we'll the South African will then do what we need to do.
Yes, we get to that. Perhaps we will get to that. I'm not sure. We may not get to that. But what I'm asking, when that high level team was put together, these are high-ranking police officials.
Yes.
The NPA was there, am I correct?
Yes.
When that team put together such a team, what was the purpose of going to Tanzania? Apart from what happened in Tanzania, the team, obviously, when they were composed, there was a mandate. They went to Tanzania with a mandate to do what?
Yes. You find that in the papers, Justice, they say that they a decision was made that the multi-department team from South Africa should be assembled to travel to Tanzania to deal with the matter.
Yes, to deal with the matter. This is why I'm not clear. Yes,
and
to deal with the matter. What is to deal with the matter? I'm not sure.
Well, I'm bound by the papers, but...
Yes, but because we faced in this court with two processes, and these two processes do not operate the same way. This is why I'm interested to know which one of these processes the South African team went to Tanzania for.
Yes. What you do know is that that's what they say, and then after they arrived there, you know what the multitask team informed Tanzania. And that is that...
they went there to deal with the matter?
That's what they say when they decided, after this team was assembled, to deal with the matter.
But it's not clear how to deal with it.
So. That might be so. But they they say to Tanzania, during the first meeting there, it's to ascertain the identities of the persons reported to have been arrested by Tanzanian authorities, and once that is done, Tanzania will advise on the government's decision as to handling the matter. Now, I'm sorry to be interrupting you. I just want to make sure that I understand whether the team, the South African team, went there to assist with the deportation, because it seems to me not to be in dispute that when they were asked by the Tanzanian authorities about extradition, it was clear that there were no extradition papers and they didn't come there to initiate any extradition process. They didn't go there with the idea in mind to do anything at that stage. They went there to go and ascertain, was it Mr. Bester and who was with him, verify their identities, and then let them be guided by what happened there.
And then other means could not be done, could not be made to ascertain the identity of Mr. Bester.
Yes, it could probably be. Of course, there could be other means, but this is what the government decided how they felt they had to deal with this matter. So that's why I said one can ex post facto, one can probably criticize it, but that's how they felt at that stage was the correct way to deal with this matter, which by that time had reached the public and piqued the public interest.
Okay. Now, the South African team gets to Tanzania. We hear that there was some kind of agreement. And in my mind, I'm wondering whether the team, whether it did not occur to the minds of the team that if they were part of the deportation, and that they didn't have to participate in a deportation, and that a deportation could be done by Tanzania. Why there was an agreement? What was the agreement for?
Well, the HA will probably be better suited to address you on that. The South African contingent, as far as the task team went, to go and see to the matter, and they informed Tanzania that they will be guided by whatever Tanzania does. Very interested to know that it's Mr. Bester, and they also stay now that it's the applicant. And the police's role from that is really nothing. When they go back the second time.
Yes, I'm sorry to interrupt you, but what was the agreement for or concerning?
That is something that the DHA will address you on.
Okay.
That falls within the purview of I'm going to stick to the first to third respondents who are present to their involvement in this matter.
Okay. But should I leave this line of questioning understanding that deportation does not need that there should have been an agreement, that it could be done without an agreement?
Yes, I think that it could, but the converse is that where Tanzania takes a decision to deport, under Escort, there's nothing in international law that says they cannot do that. That's the converse, Justice Chiki.
No, I'm just confused by the presence of the agreement.
Yes.
And the fact that the whole team of high-ranking officials went to Tanzania.
But they didn't go, there wasn't an agreement, there was no speaker agreement when they left. When that first team, that first delegation left, the delegation itself hadn't had a meeting with Tanzania at all. Their first meeting, they explained that when they arrived, it was Easter weekend, so they could only see Tanzanian representatives the next day, and it's at that meeting that they say that they made clear that the purpose of the engagement was to ascertain the identities of persons reported to have been arrested because they needed to determine that as well. And once that was done, Tanzania would advise on government's decision as to handling the matter, and they say they showed deference to Tanzania and to follow their processes before they would decide how South Africa would react and what South Africa would do.
Thank you, Mrs. Nandipha. Thank you, Sir.
Justice Nandipha?
Yes, Justice.
Justice Makuka, paragraph 20 of his judgment, concludes, sort of intimates that the question whether this was a disguised extradition is probably a matter of the law, a conclusion of law. I would like to know why, if you do not, I suspect you might not agree with that. Why so? Why can't wouldn't that conclusion be reachable, if you will, on the founding affidavit considered together with the answering papers?
This is the manner in which, firstly, it's not. It is dependent on the facts of the matter. You can't divorce whether you make such a finding from the facts. And it's the manner in which the applicant went about this matter. Firstly, she approached the court with a version that she jettisoned. She no longer relied on it.
I'm not sure that the version is that contradictory. It seemed to me that what the subject of the objection was the conclusion that you did not plead a disguised extradition in your founding papers. You pleaded abduction, you pleaded unlawful arrest, you pleaded that you were arrested in Tanzania. You pleaded that after that you were taken to South Africa and you were taken to court.
Yes.
And then there is the answering papers. So I'm trying to get your submission, your view on why would a conclusion, as a matter of conclusion of law, not be reachable that actually having viewed all of what happened here from these two sets of affidavit, even without going to the replying affidavit, that this must have been a disguised extradition?
The question isn't so much whether that decision would be correct, but whether it could be made. If I understand correctly.
Yes, I think I do want to, whether the correctness of it as well.
Well, Justice, we respectfully submit that, firstly, in order to get there, that question of law was not the conclusions of law that the applicant approached the court with in her founding papers. In her founding papers, it was quite a simple case. I hear what the court says.
The court is not precluded from reaching a conclusion of law that is from facts that are contained in the affidavits.
Yes, but it wasn't the applicant's case.
What was it?
It became her case on appeal.
What was
Or
it?
actually in the High Court after when it was argued. Her case initially was simply the police went there, abducted her, and brought her back to South Africa.
Of course. And then there's an answer to that from the respondents themselves.
Yes, Judge.
And they said, that abduction, as she says, or arrest, was followed by the court proceedings. And then the answer supplements, so to speak, what she says, because I do not quite see anything except the fact that the respondents say we didn't arrest. It was not an arrest. We didn't go there to arrest her.
That's what we say.
Yes.
That's what we say. And that was the case we were called to court to meet. And we met it. That is what she told the respondents, this is my case. I'm inviting you to court, and we went there and we met that case.
Yeah, I'm not sure that I
And
understand. What I'm saying is that why were the pleadings as they stood at the filing of the answer so such that that conclusion could not be made?
well, it's inherently prejudicial because before the answering affidavits were filed, and Home Affairs joined and filed their affidavit, the applicant said, I'm not relying on a disguised extradition. I hear what you're saying, but that's not the truth. That's not what happened. You went to South Africa, the police, you abducted me, blindfolded me, and brought me back across the border. That's the case. We went to court. We were invited to court to go and answer, Justice Dambuza. That's the case we answered.
So he's wrong in saying that would be a conclusion of law.
With respect, we can't divorce it from what we were supposed to go and do at court and what the applicant approached the court with.
Yes,
Justice McLeod.
still on the purpose of the visit by that high-level delegation.
Yes.
You mentioned that one of the reasons was to collate some information. What was the purpose of getting the member from the NPA to go to Tanzania?
I'm sorry, Justice, for purpose of?
The advocate from the TPP's office. Why was it necessary for that particular member
Well, I understand.
to go to Tanzania?
He said to make sure that whatever happens there, they want to be able to prosecute Mr. Bester and the applicant, if it's them, at the end of the day, to keep them in line, I would suppose.
How are they going to make sure? I'd like to get some understanding.
He's probably giving them advice, Justice, and you'll remember that he didn't attend certain of the things. He didn't, for example, go to the identification with when the person identified Mr. Bester, because somebody actually went with from Correctional Services who could identify him on face value. He didn't partake in that. So the purpose of him being there was to ensure that, and that goes against the case where the applicant argues for a ruse. He went with to ensure that the criminal proceedings that would follow is not compromised. That's how I understand the papers of what his purpose was.
What criminal proceedings?
Well, Mr. Bester,
remember, we are talking about they received information that
yes,
people have been arrested. Now we're talking about criminal proceedings
no,
in Tanzania.
No, I'm sorry. That's not. What I'm saying is, when we look at the papers, they have received information that Mr. Bester was arrested there. They go there to go and ascertain whether it's true, and they say that he went with to make sure that if there are later proceedings against Mr. Bester and or whom was with him, that wouldn't be jeopardized. And there's nothing wrong with that, with respect. So in future.
And that the applicant and Mr. Bester were wanted for certain criminal charges that would have been. And you have this delegation traveling to Tanzania.
Yes.
The police said you were only there to confirm certain things and eventually provide the escort. Could one not then say that basically what happened here, the presence of this high delegation went beyond a passive escort, but was basically some form of law enforcement involved by this group?
Just as we could say a lot of things, but on the papers they explain to the court. And that's why I say one can, in retrospect, one can probably, if one wants, you can criticize it. But that doesn't mean that there was anything wrong with the decision. The decision was you're not going to send low-ranking officials to Tanzania if you want to go there. They decided to send this multi-department team. And on face value, the fact that that team went there doesn't lead to any. It's the only justified inference from that can't be that there was some kind of ruse afoot or some kind of untoward conduct. In their wisdom at that stage, they felt that sending this team of highly ranked individuals to another country was the correct thing to do.
In a normal deportation or extradition process, what would be the normal process? Would officials travel to the country for when they want to extradite?
I really can't say, Justice. I don't think there's anything in the papers dealing with what would ordinarily happen. But that doesn't mean that it can't happen in a case like this, where the public interest has already peaked. They hear that this escaped convict has allegedly been arrested, and they decide to send this multi-department team there to go and see what's going on, and to make sure that it is Mr. Bester. We're not wasting their time. Hindsight's 20/20, but at that stage, the department felt that was a justified thing to do, and I don't, with respect, think that the mere fact that they do that can lead to the inferences or the conclusions that is drawn from it, with respect.
On the issue of consent, what is the evidence that was, one can then gather that the applicant gave informed consent?
The police say, from their perspective,
bearing in mind that she was likely to be charged with the number of charges. Okay.
The police say that she was telling everybody she wants to come back. We know why she would want to come back to South Africa. Not only is this her country of birth, but her children are here. The bail proceedings, bail affidavit was admitted in the SCA. In that affidavit, she said that she was actually taken out of the country against her will. And then it goes on to deal with why it's important for her to look after her children. So she had every incentive to come back to South Africa if given a choice. And I think one of the justices said there's nothing wrong with her in those circumstances of hitching a ride back to South Africa. The plane was there.
It is. The court said that one would have to make an informed consent that would also entail having been apprised of whatever charges that may be leveled against her, was she informed of what awaited her once she got back to South Africa?
We know that she was offered consular services, which would include legal services. We know from her affidavit and her bail affidavit that she appointed legal representatives there. So she would have been well aware of her rights. She's not a lay person. She's a doctor. And what the police just say is that she said to everybody she wants to come back. She said that to everybody that was willing to listen. And why wouldn't she want to come back? Even if she had to face possible prosecution. She had her defense already. She's going to say that she was abducted. She might still succeed in proving that. That's what she said in her bail affidavit. She didn't leave a country voluntarily. Why won't she return to it?
Thank you, Sir Chair.
Snellenberg, do you agree that there were only two ways that the applicant could be taken out of Tanzania? It was either deportation or extradition, or can you think of a third or more ways?
Well, the third one would be unlawful.
Yes.
Yes.
Well, maybe not only the third one, but let's get there.
Yeah.
Then she comes to court, the applicant, and says, I wasn't extradited, because if I had been extradited, I would have had to appear in a court in Tanzania. So that is common cause on the papers.
Yes.
So that leaves deportation. Now I know we're harping on this question of this delegation on this chartered plane to Tanzania, but it's important to me because if SAPS went there with the other officials, they must have had a reason for going there, and you say it's to A, to identify, and B, to escort back. Did I get that right?
Not the first time. The first time they went with wasn't to escort. The first time they went with was, for them it was important to make sure that the alleged person was in fact Thabo Bester, and this delegation would be informed by Tanzania how they were going to deal with this matter, and then the South Africa would decide. The high-ranking police officials, I think, merely represented the fact that this was by then a high-profile matter that had gained a lot of traction in the media of this person, this convicted felon, let's call it that had escaped. You can't, with respect, read anything more into that. The fact that they sent high-ranking persons, I understand that. I mean, if you're going to travel to another country to ascertain certain things, you're going to send high-ranking people. You're not going to send, I don't want to say nobody, but a low-ranking official.
But I'm not so much worried about their ranks, but we are well into the 21st century. The police not heard of fingerprints and DNA testing information. Why must they take a whole delegation on a chartered plane? I can imagine how much it cost me my tax money. So how much? Why don't they just check on DNA or fingerprint evidence whether these are the people they're looking for?
I duly take note of that, and I think this court won't be the only person that would have felt that. But the fact of the matter is, they took a person with that worked at correctional services where Mr. Bester was held, who on site value said, no, this is the person. So we're not wasting our time. And later it was confirmed by other means. So yes, there was other means to do it, but in their wisdom at that stage, they decided that was the most appropriate way to go about it.
I don't want to sound facetious, but apparently Mr. Bester is very adept at disguising himself. I would suggest to you that fingerprints and DNA can't be disguised. A person can disguise him or herself. You go there and face value, say, no, it's him, and he's a disguise. I'm just saying that to you. But let's move on. This is one of a few factors that I'm raising with you. This is the first point.
Yes.
They go all the way there to try and identify a person by sight, whereas they could have used fingerprints and DNA. The second thing is this. They have with them the head of SAPS Legal Services, a general.
Yes.
They have with them a high-ranking official in the DPP.
Yes.
Those two must have told them, we are legally trained. When we go there, we must find out whether we are assisting or deporting a person, or whether this person is being extradited. Is that fair to accept?
Well, they say so. They say in the first meeting that they would be informed by the Tanzanian government's actions.
And Tanzania asked them, have you come with the papers for the extradition?
Yes.
They say no.
They said, not yet. We'll wait to hear what you want to do. But first, they are concentrating on ascertaining who this is and whether this is indeed Mr. Bester. And that was actually the person of interest.
But now they come back, and Ms. Magudumana says there's been no extradition. I was unlawfully abducted. This court in Zealand authoritatively said, all you need to plead is that I was unlawfully deprived of my freedom. Then you must justify that detention. Is that right?
But I think this court said once, you said that there was an infringement, and here the accusation is the SAPS arrested and abducted me, and SAPS says it isn't so, and it appears it wasn't so.
Prejudice for SAPS?
Well, in what sense, Mark?
I don't understand what SAPS's problem is. It seems
we're still being held liable.
Well, it seems to me that what had happened here was that SAPS went there to arrest. This is my impression of all of this. And when it turned out that the Tanzanian government is expecting an extradition papers, people then turn around and say, well, this is a deportation. And it's actually a disguised extradition, and SAPS was complicit to it. That is what it looks like to me on the papers.
Mrs. Majid, I don't think that's on the papers that is a conclusion that one can draw with respect. Not from what SAPS have said on Plascon evidence.
Is your case the fact that she didn't mention that this is a disguised extradition is fatal to her case?
Well, she said that you abducted me, South African Police Services, on 6 or 7 April. You forcefully took me and you kept me somewhere, I don't say where, and then later took me to an airplane. Nobody else is involved. There's no formal process. Tanzanian authorities is not involved at all. This is the case I'm bringing you to court to meet. That's the case we were invited and which we did go and meet. So on that version, there's absolutely no room. Then, to make matters worse, before anybody answers, Home Affairs writes a letter to say, well, this is actually what happened. And remember, SAP is just merely spectators. That both judgments in the SCA accepted. And she replies and says, I'm not interested in that. I hear what you're saying, that might be a disguised extradition, but that's not my case. I'm not going to join you. I'm not interested in you because that's not what happened. What happened here is I was unlawfully arrested, abducted from Tanzania by the SAP. That is what you, South African Police Services, must, that's the case you must come and meet, and we met it. And we've proven that we didn't.
What was the DHA immigration official doing on that flight?
Well, they were part of this multidisciplinary team, and you'll remember, Justice Majid, that Tanzania was informed that depending on what they would do, the South African would obviously consider its position. So it's quite fair to say that they were there probably to deal with whatever happened, transpired in relation to this matter from the Tanzanian government.
Do you accept that in the position that she was, this applicant wouldn't know, she would see members of the police there, but she wouldn't know who the arresting authorities are, whether it's DHA, whether it's SAPS, or whether it's more of them?
Justice, she knew, she got that notice on the airport when she was, remember she brings this application after all this happened. She knew very well that she was deported. And she approached the court not with a true version. It's not correct. By the time she deposed to the affidavit, she knew a lot, which she didn't disclose.
So I just want to conclude. The sum total of your case is that SAPS went there for the first trip to go and identify, and only to identify.
And to see how this matter develops, yes. At that stage, they were interested in knowing whether this is Mr. Bester, and then the process would unfold.
Say again, and I'm sorry if I sound like a stuck record.
No.
Why did they have to go to Tanzania to A, identify, and B, see how this process develops? You could do this from South Africa. And tell the Tanzanian authorities, keep them in custody while we check fingerprints, while we check DNA, and then we decide what we're going to do. Why go there? It seems they went there to arrest.
Just as you can go and you can criticize it, but they, in their discretion, deemed that was the appropriate thing at that stage to do, is to send this multi-department team to Tanzania to see to this matter. And that doesn't lead to only one inference, or the inference that they wanted to go and arrest them there. Because they were clearly alive to the fact. They said to Tanzania, follow your processes, let us know, and then we will decide how we have to approach this matter.
Thank you, Mr. Snellenberg. Just one question. Let's assume that we're not with you on the merits.
Yes.
And you did urge us to take a balanced approach to the question of remedy.
Yes,
in your view, how would we strike that balance on the one hand to ensure that we vindicate the rights that have been violated, which is what the case law of this court tells us?
Yes,
secondly, to send out a clear message to law enforcement authorities in South Africa that notwithstanding the public interest in the matter, notwithstanding the sense of public outrage, we are after all a rules-based society that must conform to the rule of law. And thirdly, to ensure that the criminal justice system is not unduly undermined by departures from the norm. What kind of order would you propose?
Justice, a paragraph containing that already would send a very clear message. A finding in terms of Section 172(1)(a) will already send a very strong message. But there are victims here that are not here. They're not represented here. They weren't part of these proceedings. They have an interest and a stake in this matter. Public has a stake in any criminal matters. And the approach that the applicant proposes here to say that, and I mean, there's, even if you get to that point, Justice Glapen, where you find that that the manner in which this happened doesn't carry this court can't condone it. This isn't a Abraham matter. The applicant wanted it to be an Abraham matter. That is the case she went to court with, but it isn't. And we can criticize the role players later if a court makes those findings, and we can say that, why did you do that, and why did you waste the taxpayer money? But that's not, at the end of the day, what's at stake. What's at stake here is the victims of this matter, the fact that the public wants to see justice, and justice can be that she's acquitted at the end of the day as well, but that she stands her trial. And we've raised this from the High Court, but the applicant said no, and the SCA majority said it's binary, but 172 is quite clear. And we respectfully submit it would be a travesty, it would be a dark day in this matter if there wasn't, at the end of the day, vindication also for the victims in this matter. It's not a victimless crime.
Thank you, Mr. Sandberg.
I appreciate it. Thank you, Justice.
One question, Mr. Snellenberg. I'm just concerned, and I'm following on my colleague Justice Mhlanhla's questioning about, and Justice Cheekley, about the circumstances in which the return to South Africa was affected. At what stage was the applicant blindfolded?
She wasn't.
She wasn't. So the allegations of blindfold arise in what context?
No, it wasn't true.
Are you saying that's false?
The South African Police Service never blindfolded her.
All right. And then just on the remedy, what interests would you say would need to be balanced if we were on Justice Collipan's question? What would we need to balance in trying to determine if she had been wrongly returned to South Africa and unlawfully so? Then what are the issues that we would need to balance in deciding what would be just and equitable remedy?
Just may I just add, previously, she wasn't blindfolded, she was never arrested, she was never cuffed. You'll remember that she was on the plane uncuffed. So there was nothing
But there's an allegation at some stage in the papers that there was blindfold.
She says so, in her founding papers, on 6 or 7 or 12 when she was taken to the SAPS denies it, says it didn't happen. They didn't do it.
But this perhaps brings home the importance of not affecting, doing other people's business. You know, if there was a deportation, then of course the deportation could have been affected by Tanzania, and once affected, the law enforcement authorities in South Africa could have been ready to receive both Mr. Bester and Ms. Magudumana.
But the Tanzanian authorities took her to the airport, if I understand correctly, not the South African police. So any allegation by her to the effect that they did anything would not be right. It's not correct. You can't accept it in any event on face limits. This is as for the considerations. What you obviously need to take into consideration is that the nature of the crime, the nature of the proceedings, and the victims of those proceedings, and the public interest in the fact that they want to see that the people are brought to justice, or at least stand their trial. Those are the most foremost, but they are very important, and they weigh very heavily. And obviously this court will also bear in mind, as I think this court already established in Kahota, one will go and look at what the irregularity was as well.
All right.
But we feel very strongly, Justice Savage, that it would really be a dark day, a travesty of justice if this applicant. Remember, the warrant for I know somebody just said something, but the warrant for arrest was actually issued in South Africa already, the J50, before the news broke that she was located in Tanzania, or identified as one of her persons there.
Thank you.
Mrs. Snellenbeck, you've said twice now that it would be a dark day, a travesty of justice if this applicant,
yes.
If the relief sought by the applicant is granted. Is there anything at all preventing the law enforcement agents of this country from arresting the applicant in due course if she is released as is sought in these proceedings?
Well, I think that depends on what the order is that the court makes. If the court merely
Well, assuming that this court is with the applicant, finds in her favor.
No, I'm taking it a bit further. It depends on what this court's order is. Let's accept for sake of argument that the court is with the applicant. If a court merely says that bringing her to court that day and arraigning her, sending her to be held pending the trial, that is unlawful, that's one thing. But what the applicant reads in quite clearly is that she cannot be, no criminal court in South Africa will have jurisdiction over her, again, because of the manner she was brought back to South Africa. If that is the consequence or the effect, then my submissions are, of course, very relevant. So it really depends on how the order will read that this court makes, how it deals with this matter.
In response to Justice Chandler's question about whether it can be said in these circumstances that the applicant gave informed consent to return to the country, you said she's not a lay person. I'm not entirely sure what that means because she's a medical doctor. She's not a lawyer.
No, that may be.
But then, where I'm going is then you said she was legally represented in Tanzania. I just wanted to ask if you can point me to the part in the record where what you submit is recorded, that she had legal representation and would have been advised of her rights?
I didn't say that she was advised. I say she had, on her own version in the replying affidavit, she said she appointed an attorney in Tanzania, and then in the bail proceedings, which were placed before the SEA, she also said that she appointed a legal advisor.
And
what advice he gave her is privilege.
We
obviously don't know what that was.
All right, well, fair enough. The minority judgment in the SCA at paragraph 117 sums up the evidence as being that the Department of Home Affairs took the appellant as she was there into custody from the Tanzanian authorities and facilitated her deportation to South Africa. assisted by SAPS and the NPA. Do you accept that as a correct summation of the evidence?
Even on Home Affairs affidavit, Chief Justice, SAPS were merely spectators there when the handover occurred. They never arrested her. They were there to escort Mr. Bester back to South Africa on the plane to protect the Home Affairs officials that were on the plane. They weren't part and parcel of anything relating to the applicant. And they didn't arrest her, we know that, because correctly so, both majority and minority judgments found so. The mere fact that they were there doesn't mean that they were part of anything. We know why they were there, because Mr. Bester would come back and he was considered to be a dangerous person. And they were there to, on the plane, ensure that the department officials were safe. And there's nothing, I would respectfully submit, there's nothing untoward in that. Nothing at all.
Well, I'm still, you've been asked several times about what this high-level delegation went to do in Tanzania, and yes. I'm not satisfied. I must say that I'm not satisfied by your answer. But I suppose you can't take it any higher than you've already submitted.
Chief Justice, I don't think that there's anything wrong with the answer with respect. At that stage, they felt that it was the appropriate thing to do. In hindsight, it is open to criticism on various levels. But that doesn't mean that there's anything untoward, that it was intended to be anything untoward, and that's also not reconcilable with their version. If one reads their version, they didn't go there. At that stage, they went there to, in their mindset, verify identities. They explicitly said to Tanzania, when these matters were discussed, that you decided what you want to do, and the South African government will be informed by that. And that is not akin to, with respect, can't lead to a finding that they went there with any nefarious purpose, with respect. It might be frowned upon from the taxpayer's point of view. That's what they thought was right, and I respectfully don't think that there's anything. That version can't be rejected as palpably untrue or far-fetched, clearly untenable, with respect.
As I understand your submission, you say they went there for, this is the only reason, no tangible reason you've given, that they went there for the purposes of identifying Mr. Bester, well, identifying these three people.
Justice, you know what the evidence is. They say they went there to go and deal with the matter.
Yes.
And one of the primary matters of import to them at that stage, and I accept it must have been from a police point of view, was, is this Mr. Bester? Let's just make sure it's him. And as I say, one can criticize it. One can criticize it from a taxpayer's perspective as well. But that doesn't mean that it's the only justified conclusion, or it's even a reasonable conclusion that they went there with any ulterior motive. With a lot of respect, I don't think the evidence leads to that.
Well, it's just working on their version, yes, that they went to deal with the matter.
Yes.
How would the NPA deal with the matter?
Well, they went there to do what they wanted to do, and they said to Tanzania, well, you decide what we want to do, and then we'll decide how we have to work. And I don't think there's anything wrong with that.
Thank you, Mr. Senator.
Thank you, Chief Justice, Justices.
Would this be an appropriate time to take the lunch adjournment?
Chief Justice, be in your hands. Your court.
All right, let's do that then. I'm hungry. Until 2 o'clock?
If it pleases the court.
Then South Africa would be obliged to say, well, we are not taking her back, and you have to keep her until and unless we decide to bring an extradition application. This is unsustainable in the context of territorial sovereignty, because no state will or is able to be dictated to by another state to keep its nationals. Tanzania has a right to deport persons who it finds illegally present within its territorial jurisdiction. And South Africa has an obligation to accept return of its citizens. Section 2.1 of the Constitution says that. It says that every citizen has a right to enter South Africa. But this is subject to verification of citizenship. And once citizenship is verified, South Africa cannot refuse to accept its citizenship. Now, the applicant attempts to equate an agreement to accept a deported citizen, which is a constitutional mandate, with a surrender under extradition law. Now, these are fundamentally different concepts, and let me explain why we say so. This court in Mohammed versus the President of the Republic of South Africa set out and identified thereabouts. Subsequent to her arrest, when she was already arrested by Tanzania for transgressing its immigration laws, Tanzania informed us, as South Africa, as the sixth respondent, that the applicant was apprehended and was alleged to be a South African citizen. Now, this is fundamental because our Constitution mandates us to accept return of our own citizens. Identity is fundamental. And let's go back to why it, in this day of electronic ages, why could it not be as simple as to send fingerprints and photos and electronic means of verification? If we look at the facts of this case, we have individuals who manufactured a fake death. We have individuals who lived at large for a number of months amongst people of South Africa and were unnoticed. We have persons in this instance who left the country and were able to go as far as Tanzania before they were apprehended. So therefore, it was fundamental that given the circumstances and the propensity to persuade and to manipulate persons, as they have indicated in the past, it was necessary, certainly from the six respondents' perspective, from the Home Affairs, to go out and actually take the fingerprints and verify the correctness of the citizen, because once they are verified as citizens, we are obliged to take them. That brings me to the deferral to Tanzania. Once the applicant's identity was confirmed, South Africa deferred to Tanzania's sovereign jurisdiction. It must do so because the Tanzanian Immigration Act, which we find at case lines 011.196, provides for various options. For example, Section 12(1)p permits prosecution for immigration offences, and that you will find at case line 011.1 at 106. Section 21.1 allows for the grant of conditional release. So Tanzania has a wide discretion on how to conduct itself and towards the applicant. It was not simply a choice. Do they want to deport? Do they want to extradite? There was a range of options, and we as South Africa cannot dictate to Tanzania what they wanted to do. This explains why, when asked, are you bringing an extradition request, we said, we will defer to your decision. It is not that we could not bring an extradition request. There is no reason why an extradition request in this instance would not have succeeded. The applicant is a common criminal. She is not particularly political or in any way or to be protected. We do not have the death sentence there. In the event that an extradition was brought, we would have succeeded. There was absolutely no reason why Tanzania would not have extradited her back to her country of origin. However, an extradition request prior to Tanzania's decision would be preempting its sovereign right to determine what to do with an illegal alien. And that South Africa cannot do, which is why it specifically deferred and said that we await your decision. There is absolutely no evidence on the papers that South Africa was in any way involved in the Tanzanian decision to deport. They informed us of her arrest. They informed us of their decision to deport. There is no collusion. There is no influence. There is no, yes, there was a delegation that was sent. But the decision in the old end was that of the Tanzanian authorities. And in addition, we point out that the Tanzanian Immigration Act, specifically in Section 12.1L, which you'll find at case line 011.1105, requires Tanzanian immigration authorities to cooperate with other countries' immigration authorities. Now, agreement and cooperation necessary to implement a lawful deportation cannot, without more, be transformed into a disguised extradition. And that is because the decision to deport was Tanzania's, and it was made without South African influence. The decision to implement necessitates agreement, because as we point out in our heads, there is a quote, and my learned friend read a bit of the quote, but he didn't read the full quote. The full quote from the rapporteur reads, "A state may not just conduct an alien to its frontier and push him over without engaging itself in responsibility to the state to which he is thus forcibly expelled. It may therefore only deport him to a country willing to receive him or to his national country." And that makes imminent sense, because we do not find, even in South Africa, that illegal immigrants are simply taken to the border. Often they do not have passports. In this instance, the applicant was found in possession of 3 passports, none of which had an exit stamp. There is no manner in which she would have been allowed to return back into the country unless it was facilitated by the Department of Home Affairs. And given that we have an obligation, a constitutional obligation, to allow entry of citizens into the country, it was imperative to facilitate this. This is why we needed to be in Tanzania and to facilitate her expulsion, out of Tanzania. Now, South Africa agreeing to accept the return of a deported citizen, as mandated by the Constitution, is very different from South Africa requesting the return of a person. A handover, which I come to now, is in a deportation, is a logical implementation of the expulsion procedure. The deporting state retains control over the deportee until removal from its jurisdiction. So custody of Tanzania only terminates once the flight left the territorial jurisdiction of Tanzania. Now look, and this is what we must understand, because in extradition, it is very different. In extradition, a state surrenders custodial authority on request pursuant to an extradition process, and the extraditing state relinquishes custody on handover. That handover can be within the jurisdiction, the territorial jurisdiction of the extraditing state. So the handover in an extradition is the operative judicial act. In a deportation, the expulsion, the leaving of the territory, is the fact. And that explains why, if for any reason the applicant in a deportation had been on the runway and Tanzania had, for some reason, decided, I don't want to deport her anyway. It was open to them to get onto the plane, remove her, and South Africa would not have had any say. Whereas in an extradition, as soon as the handover is completed, South Africa would be able to say, you cannot take her. You have extradited to the extraditing state. And that is the fundamental difference. So, with extradition, it is not necessary for the receiving state to lawfully admit or facilitate entry into its territory. This is because immigration authorities are not involved in an extradition. The criminal proceeding process papers are used, not the immigration proceedings. So, once this distinction is maintained and established, the Supreme Court of Appeal majority judgment is plainly correct, because it is evident from the papers that there was no unlawful conduct by the SAPS. No relief was pleaded by the DHA, and a disguised extradition cannot arise without a request. Now, let me go to this competent relief against the DHA. And I'm not going to spend much time. I have one submission. And the submission is this. The Department of Home Affairs still does not know what case it is to meet. Mr. Katz submitted that it was the handing over of Tanzania to the immigration officials represented by the DHA was unlawful. So, in other words, it appears accepts this premise. And because once the arrest is accepted as a sovereign Tanzanian immigration arrest, the premise of unlawful South African coercive conduct disappears, because the arrest was made by Tanzania. The apprehension was caused by Tanzania. So the SCA then, majority judgment, then correctly applied Plascon-Evans. It correctly held that Zealands did not shift the onus. and it correctly referred to Mahlangu. These authorities matter because they establish that the onus only shifts once the identity of the alleged unlawful actor is established. And we know now that the applicant failed to establish that the SAPS arrested her or abducted her or exercised coercive authority in Tanzania. If it is the applicant's case that the Department of Home Affairs somehow unlawfully took her into custody, that cannot be, because Tanzania does not lose custody over an illegal deportee until that person is expelled from the state. So although they released her to us, they retained custody. Now I get to the majority judgment's misconstruction. The minority judgment, apologies, it is well written. It is concise, but it operates from a mistaken premise. It is this, that once a fugitive is involved, extradition is the exclusive lawful mechanism for return. This proposition is unsupported in international law. A fugitive has no constitutional right to demand extradition. Extradition exists for states. It is the prerogative of states, not fugitives. The decisive question is therefore not, was the applicant wanted in Tanzania? The decisive question is, why did Tanzania remove her? They removed her because she was an illegal, prohibited immigrant who had contravened their immigration laws. The sovereign immigration purpose, which Mohammed reiterates, and this court underpinned, that the purpose never disappeared simply because South Africa also wished to prosecute her. Now, we have cited many international cases in our heads of argument which underpin this, this principle that a state is entitled to deport a fugitive, notwithstanding that the fugitive is wanted in his country of origin. A case in point is Soblem, and therefore, with regard to the Supreme Court of Appeal minority judgment, it conflates deportation cooperation, which is necessary for the implementation of the expulsion, and extradition collusion. There is no collusion here. South Africa was not involved except in facilitating her return to South Africa. Now, I have dealt with handover, and I do not intend to belabor the point. I will take it in argument. And safe to mention that the question is, at the moment of handover at Kilimanjaro Airport, who still possessed sovereign jurisdiction over the applicant? And the answer can only be Tanzania. Why do we say this? Number one, she remained subject to the Tanzanian deportation order. She remained under, and why we say she remained subject to the Tanzanian deportation order is because the Immigration Act specifically provides, and Maylena Jr. will tell me the section, I think it is section 27, specifically provides that unless revoked, a deportation order continues to exist. Then secondly, She remained under the Tanzanian Immigration Authority because that is what the notice of prohibited immigrants notice said. It said, escort out. And she remained in the Tanzanian territorial sovereignty. So the handover was simply a logical implementation of deportation. It was not surrender of criminal jurisdiction. So the cases which the applicant relies on do not assist. Cases like Horse Ferry, which concerned a helicopter and deliberate collusion with police. Cases like Bennett, like Ibrahim, like Wallam, which was not followed in December, and Matlala. These features which are present in this case were not present in all the authorities. There was no clandestine seizure of the applicant. She was arrested because she contravened immigration laws. There was no covert rendition, no violation of Tanzanian sovereignty, and no evidence that South Africa procured the immigration arrest. The Tanzanian authorities acted openly under the immigration statute. Lastly, the applicant's argument produces an untenable proposition. It is that once a fugitive enters a foreign state illegally, that foreign state loses its deportation powers and must instead retain the fugitive pending extradition. And this cannot be correct. We cite a case called Bembenek and Soblin, which states very specifically that a state is not required to keep an unwanted illegal alien merely because another state seeks prosecution of the same individual. Similarly, the case of Westfalen makes it clear that a receiving state may welcome deportation without becoming complicit in an unlawful extradition. But critically, South Africa did not request extradition. And under Schultz, this court said only the national executive may initiate. And I understand that this was after. But without an extradition request, the SADC protocol never activates. So the entire structure of the applicant's case rests on transforming lawful sovereign cooperation into unlawful collusion. Cooperation between sovereign states is not subterfuge. And to receive one's own deported citizen is not disguised extradition. We at the very last, we are aware that our heads were late and we asked for condonation. We are aware that condonation is not there for the taking. The delay was regrettable and is not treated lightly. And we submit that the delay is fully explained in the affidavit before this court and was not occasioned by willful disregard of the rules or contempt for this court's processes. And in conclusion, we submit that this case fails at every level. Factually, the applicant failed to establish South African arrest or coercive conduct in Tanzania. Procedurally, no competent constitutional relief was pleaded against the Department of Home Affairs. Legally, the applicant conflates deportation with extradition, and jurisprudentially, the minority transforms ordinary sovereign deportation cooperation into constitutional wrongdoing without a factual foundation for collusion, deception, or territorial violation. The SCA majority judgment correctly refused to do so. We therefore submit that this application should be dismissed.
Ms. Mayet, here at the center.
Yes.
Thank you. Thank you. Can we just examine a certain scenario, and I'm interested to hear your comments on that. In this scenario, when you were making your submissions, you said that Tanzanian authorities had already decided to deport the applicant. And when the time came for the South African authorities to come to Tanzania, a decision had been taken and they were preparing to deport the applicant. Is that what you submitted? At least their minds were set on going ahead with the deportation. You said that. Am I correct?
Indeed.
If South African authorities had not arrived in this scenario I'm painting with you, would the deportation have proceeded without their presence in Tanzania?
Justice, we know that the applicant on her version had consulted with a Tanzanian lawyer. And on this scenario, if the...
Please, Ms. Mayet, if I can just get a yes or no, because I'm trying to try and understand the submission that you made.
So
that South Africa was not involved in this process. The Tanzanian authorities had decided to deport, and they went ahead and dealt with the deportation. So I'm asking you now, in this scenario, if South African authorities had not been in Tanzania at that moment, would deportation have occurred?
I would say no, Justice. And if I may elaborate why, because in order for a deportation to take place, you need verification of identity, and you need the country of origin to
be there in the country that wishes to deport. So in all scenarios, are you submitting that in all scenarios where a country wants to deport an illegal immigrant, the country to which that person wants to go must be there?
The country that the person wants to go must agree to accept that person.
Does it have to be present in the country to agree?
It does not have to be present in the country, but there must be agreement.
Then let's go back to our scenario then. Would the deportation have happened even if South African authorities were not there?
In the event that they had an agreement from South Africa that the applicant was a citizen, and confirmation and acceptance that then the deportation would have been able to go ahead.
Are you then submitting that in both deportation and extradition there has to be an agreement?
Indeed.
So there's no real difference between extradition and deportation?
The difference is the jurisdiction and the reason for the request. Deportation is a decision by the sovereign state in whose territorial jurisdiction the individual finds itself. And the expulsion simply needs agreement from the state to which the Tanzania wishes to expel the particular person. So extradition, on the other hand, needs a formal request, and it has a very specific purpose. Because
let me try and understand so far. I'm sorry to interrupt you. You're saying that in deportation you disagree with Mr. Gatz that it can be unilateral. It has to happen with agreement of the receiving state. That is your submission. And that in extradition has to be more formal, but it also needs an agreement. Is that how you distinguish between the two processes?
So, Justice, how I am distinguishing is deportation, the decision is unilateral. The decision to deport. But a decision cannot be implemented without agreement. So
in all instances, if a country wants to deport someone, it has to make sure that it contacts the state where it wants to deport this person to. So it has to know to which state that person has to be deported. So it can't deport to a state to an unidentified state. Is that what you're saying?
Indeed. Or a state that, if the person is able to get consent from any other state that agrees to accept them. So it's either the country of your origin is the first place for deportation, and next would be any other country that agrees to accept you. But you do need consent.
Okay. No, I understood it differently. I still understand it differently, but obviously I'm going to reflect on your responses. And Mr. Katz is here as well. He'll respond if he wants to. Let's move to a different thing. So you said that the South African authorities didn't have to be there, but in this instance they chose to be there, but they didn't have to. So the applicant would have been deported even if they were not there.
Because the deportation order was ordered by Escort, because she was ordered to be removed from the country by Escort.
So the South African team went there to escort him?
Well, initially simply to identify her, and the Department of Justice, the Department of Home Affairs went specifically to escort her, because if we do not escort her, then if Tanzania escorts her, their custody of the applicant terminates as soon as their territorial jurisdiction ends. They cannot have custody. They only have custody and control over her while she's within their territorial jurisdiction. Outside of their territorial jurisdiction, they have no basis to take her anywhere.
Okay. Let's move on from that then. The submission, perhaps I didn't understand you well, but you said that the minority judgment says that extradition is the only way to deal with an alleged an illegal immigrant. Is that the submission you made?
Yeah, indeed.
Can you please show me where in that in the minority judgment of the SA that is said?
Justice, can I ask my junior, in the interest of time?
Through you, Chief Justice, can I allow Ms. Moyet to stand when she has found what she's looking for, so that other colleagues can keep on asking questions? You can respond later, Ms. Moyet.
Thank you.
Thank you. Thank you, Chief Justice.
Ms. Moyet, at the side. You said in your submission that you still don't know what this case is about. Now, is that based on the pleadings itself, that no relief was sought against your clients in the founding affidavit, and also that no relief was sought no amendment was sought And 3, does that mean that you did not know, I mean your clients obviously, did not know what the case they were to meet? 4, if we go back to the case that has been pleaded, the case that has been pleaded was that the applicant was arrested by members of SAPS. Do you understand?
Yeah, I do.
Do you want to elaborate on what I've...
So, as I understand the question, Justice, it is my case that that we do not know or fully understand the exact case against the Department of Justice because of the pleadings. There was no relief, and the amendment as well also showed no relief. The answer to that is yes, that is correct, because the applicant's relief has been perpetually evolving. For example, in this court we hear that it is the handover of the Tanzanian authorities to the sixth respondent. That is the unlawful act that it is alleged to have occurred. Whereas previously, is it the agreement? Which portion of the agreement? The arrest, obviously, we were not involved in the arrest. And then the second question is, does that mean what case we were to meet, even though we pleaded?
Let me make it easy for you. I just want to understand. I'm saying this against the backdrop of the entire pleadings, what I had put to Mr. Katz when he was on his feet. So, because if you contend that you did not know what case you were to meet, and you still don't know, because that's what I recorded here, the department still does not know what case this is all about. And because the relief was not in the notice of motion, and also no amendment was sought when further pleadings were exchanged, do you say, when you read the founding affidavit, the answer by the state respondents, as the SAPS, as well as the replying affidavit, you were still in the dark as to what case you were to meet, and that you only agreed to participate because a relief was sought against your client? And if that was the basis, and you said the relief is sought against our client, but the relief must have been foreshadowed in the papers. That's why your client decided to ask for a joinder.
As I understand it, Justice, my client simply wanted to put the facts before the court, and they did not foresee any relief because there was none in the papers. It was not subsequently amended. They did not foresee any relief because on the papers there is no wrongdoing except an alleged agreement, which is ever evolving. It's certainly not. If we consider the papers in totality, the papers in totality allege that the South African police were involved in the arrest and the abduction and apprehension of the applicant. It is not absolutely stated that the nature of the agreement that we allege to have colluded. There's vague allegations of collusion, but there is no substance to any of those allegations. And had we known that, for example, the handover of at the airport was specifically contingent, it would have enabled the Department of Home Affairs to obtain the relevant affidavits from Tanzanian officials.
Sorry to interrupt you. Do you raise any prejudice against your client, and if so, what is the prejudice?
I do believe that there is prejudice, Justice, particularly if this court is inclined to grant the relief that they seek.
But what is the prejudice that you did not meet in the papers, or you could not meet in the papers?
Well, Justice, we weren't able to put the full version of events to demonstrate that there was no collusion. It is a very damning finding because it impacts not only on the South African state, but also on the Tanzanian state, because you cannot have collusion alone. South Africa cannot collude by itself. So it has implications, not only for South Africa, but for our international reputation.
But Zealand tells us that the crucial test insofar as pleadings are concerned, and where there is unlawful arrest and detention, is the critical element of prejudice. Did you raise any prejudice before the High Court and the SCA? And if so, what is that prejudice that you say?
But Justice, that's just it. There was no unlawful arrest. The arrest was in Tanzania. The Tanzanian authorities arrested the applicant. There is no, the Department of Home Affairs cannot arrest a South African citizen. There is no provision for that. At most, we can facilitate a re-entry.
Just remind me, maybe my mind has just... What would have happened if you had not participated in the proceedings, joined?
It would have been far simpler, Justice, because they would simply have found that the SAPS had not participated in her arrest.
Yeah, because I'm just worried about your clients. You joined and you brought here, and no relief is sought against you.
Indeed, and my client simply wanted to assist the...
But am I making that so simple? Probably there must be a catch somewhere. Do you think you could have walked away, for example, if you had decided that you not participate in these proceedings and nothing would have happened to your clients' interests?
Well, the applicant was quite adamant that they didn't want the Department of Home Affairs involved. It is evident from the correspondence in the papers that the sixth respondent had to fight, and the application to join was opposed. So there was not only there was letters indicating that they did not want us to be part of the proceedings, and the application was opposed. Do
you understand? I'm not sure if you appreciate my difficulty. Let me try and make it very clear. Could your clients at that stage, at the High Court, especially when they realize that no relief is sought against them, could they have... I think your junior is giving you a note. Possibly it's an answer to my question. Have a look at it.
My junior informs me that I must inform the court that there was information that was being sought and requested from the Department of Home Affairs. So the Department of Home Affairs could not have simply sat back and folded our hands.
Yeah, but if the information is sought and you simply just ignore the information, but at the court, that's where everything is happening. They send you a letter, they request a particular information, you respond to say we're not interested, or you give whatever response you give. I just want to know the rationale of the Department of Home Affairs proceeding to the joint of the proceedings.
Justice, myself and as well as Ms. Matenga were brought in only last year, so I cannot assist that with that answer. But I can undertake that my instructing attorney.
No, don't worry. Thank you. Thank you, Ms. Maya.
Ms. Maya, you said to a question by Justice Matopo just earlier that, or it may have been even before that, that you needed the receiving country for deportation to agree to receive the deportee. That's not our law. This court has said that deportation is a unilateral act, and the destination of the deportee doesn't matter at all, which implies that you don't need the consent of the receiving country. You don't even need to tell them that this person is coming. So you're saying Mohammed is wrongly decided because we're bound by the decision.
Mohammed is different with respect, Justice. Mohammed was a request from a country not of his origin.
Just hang on. Can we go to the case?
A deportation.
Yeah, let's go to the case. We can't talk so loosely. Let's go to paragraph 29, please.
Before we get there, Justice, you submitted to me that I must address you on that the receiving
submissions. You make submissions.
Oh,
I'm asking you questions.
Sorry.
Can we go to paragraph 29, please, Mohammed? Because this case is not about the facts of that case. It's what this court is explaining what the difference is between deportation and extradition. So if you look at paragraph 29, it makes a general statement. It says, in principle, there's a clear distinction between extradition and deportation. It explains that extradition involves three key elements, and then it says deportation is different. It's a unilateral act of the deporting state in order to get rid of an undesired alien. The purpose of deportation is achieved when such alien leaves the deporting state's territory. The destination of the deportee is irrelevant to the purpose for the purpose of deportation, which means that there's no need for a receiving country to acquiesce or to agree to anything.
Justice, you cannot simply deport anybody to any country. You need consent. That is a fundamental basis of territorial jurisdiction.
Where in the law do you get that? Can you give me authority? The closest that I can see is Regulation 23 that was mentioned in Mohammed. Is you send that person back where where that person is a citizen of,
Indeed.
or the country where that person came from, or the country where that person chooses to go. It doesn't say you need consent.
But Justice, if we look at your one. To send him back, which is why we have in South Africa we have Lindela, where persons are kept until their nationality is verified, and once their nationality is verified, processes are then initiated with whichever country that they are found to be a national, and the countries agree to accept them, because acceptance is essential. A country like Somalia, for example, does not accept its nationals back. South Africa is enjoined to accept its nationals in terms of the constitution, but that is not always the case in all countries.
I want to move on. I'm not satisfied with that answer, but I want to move on. I'm not the one that says so, not the applicant doesn't say so. Your officials, Mr. Matthews and Ms. Moreng, say they had an agreement with Tanzania for deportation. What was the agreement all about?
The agreement was to facilitate the deportation by escort, by escorting her out. It was not an agreement to deport. That is a unilateral decision. The decision is always unilateral, as you correctly pointed out. However, the implementation to escort her out, the practical, logistical effect to give effect to the decision needs agreement.
Let's read her affidavit at page 180. Ms. Morang says the agreement between the Tanzanian authorities and the High Commission, as High Commission of South Africa, to deport Ms. Magudumana and Mr. Bester back to South Africa was reached at the premises. So that agreement is to deport back to South Africa.
Sorry, Justice.
I read it as it stands. What does that mean?
Sorry, Justice. I was trying to find the relevant. Which paragraph?
I'm asking, that's page 180 of the record, paragraph 13. If you're looking at the record, paragraph 13.
Now, Justice, before you read paragraph 13, you must read paragraph 11, because paragraph 11 is the instructive paragraph in this whole sequence of events. Paragraph 10 tells you that the Arusha Tourism Police informed the High Commission on the 8th, the 9th, they convened a meeting. But 11 tells us, on the 11th of April 2023, the Tanzanian authorities informed Harris Oshupeng about their decision to declare Nandipha Magudumana and Thabo Bester prohibited immigrants and liable to be deported back to their country of origin, South Africa. It is their decision. And in that context, we read paragraph 13. The agreement is to facilitate the expulsion.
And when Mr. Matthews says in his affidavit that because there was this agreement, Home Affairs then had the authority under Section 1 of our Act to arrest her because now she was on South African soil.
Now, I must concede there, Mr. Matthews was reading a bit too much in the Act.
It's plain wrong. He didn't read too much. He was just plain wrong. There's no law like that.
Indeed.
Now, can I just go to the pleadings? You say Home Affairs was prejudiced. You know, in Zealand, this court again said, in subsequent papers, the whole case is before the court, and it was reversed in the High Court and or the Supreme Court of Appeal, and the entire case is before the Constitutional Court. What prejudice can there be? You have been given the right of Audi. You have responded fully. Your papers are complete. You have argued the matter in the SCA and High Court and here. What prejudice is there?
And to use your own words, Justice, change in the course of action. There was no course of action pleaded against the Department of Home Affairs to change.
She must use the words disguised extradition, otherwise there's no cause of action.
For a disguised extradition to be established, it is established on the facts, Justice. Although it is submitted that it is established on the law, it is established the facts establish a disguised submission. If we look at all our case authorities and especially Mohammed, it is the factual premise that underpins it and that establishes whether or not there was collusion. Collusion is not a legal establishment. It is established by the facts. And so therefore, if a change in a course of action, you need a cause of action to change. And the sixth respondent did not have a cause of action.
I must tell you, I find this bizarre. You're standing on the sidelines here. Nobody's taking you to court. And they take SAPS to court. SAPS says they shouldn't be here. You say, you know, I want to be there. I must be there. I must protect my rights. We had a judgment in this court, Lebeya versus Menye, where we said if you are going to be affected by an order of this court, then you have the right to join. And we allow the party to join. Here you come and say, I'll be affected. Join me. Join you. They serve papers on you. You file answering papers. Now you say, but you know, I'm prejudiced. This is a matter, regardless of who it is, whether it's an assassin or a thief or a robber or a rapist, they're entitled to the protection of this Constitution. Now you say, I'm being prejudiced, you're putting form over substance, when it concerns a matter of the freedom of a person. How could that possibly be right, to put form over substance, to say, just because you said this isn't a disguised extradition, you said it late in your replying affidavit, and we insisted we be joined, and we be joined, now suddenly there is prejudice. How could that possibly be right?
But with respect, Justice, for any action, any matter that is lodged, when there's a foreseeable dispute of fact, and in this case, it was obviously a foreseeable dispute of fact, the applicant elected to go on motion papers, and also elected not to amend her papers, despite knowing that the Department of Home Affairs position. So, with respect, Justice, the SAA minority judgment therefore correctly held that a party must be bound to its pleaded case, because it is imperative that the other party know which the case it is required to answer.
I can't find the place now, but is it correct that before she launched this application, her attorneys wrote to your department and asked, your client's department, and asked, what were the circumstances of my arrest? Did you play any role? What did you do? Did she write to you?
Indeed, she did.
What did you do?
We did respond, but the letter specifically and unequivocally maintained that there was absolutely no relief sought against us.
What did the department do in response to that request?
I speak under correction, Justice, but I do believe we replied and said that it is a prior request.
You referred this applicant to the Promotion of Access to Information Act, and now you insist you join, and then you blame her for not having joined you in the first place and for not having provided a course of action. I find it bizarre, you know.
But Justice, if you look at it, the applicant has not made out a case for the relief that she seeks. Because
why do you say that?
Because there is no evidence that she was arrested by the South African, any South African officials, both the South African police as well as the sixth respondent who had no powers in Tanzania. There's no evidence of collusion. There was no extradition request. This was a very normal deportation. It was high profile, this is correct, and there was a big delegation that was sent, this is correct. But other than that, there's nothing that makes this deportation unlawful.
Now, if we are with the applicant and we say this is a disguised extradition, what do you say about the remedy?
With regard to remedy, we leave it in the hands of the court.
Now, if you represent the minister in the department, should we grant the order as prayed for in the notice of motion? What did you say in your submissions?
In our submissions, we submitted that there is no case made out and the relief should not be granted.
And nothing about remedy?
Indeed, Justice, because we are of the view that this is not a disguised extradition and the matter should be dismissed.
Yeah, thank you.
You correct me if I'm wrong, but somewhere in the papers there appears to be yes.
Thank you.
Yes. There appears to be some reliance on Section 41 of the Immigration Act. Can you just explain to me how is it relevant for the circumstances of this case.
So, Justice, if you read Section 41 of the Immigration Act, it is clear that it does not apply to South African citizens. It allows an immigration official to stop a person and inquire as to the validity of I do have the Act, Judge. If you would permit me to read it, I will just read it.
My understanding is supposed to apply to an alien in South Africa. In this case, somebody was arrested in Tanzania for being illegal, having entered the country illegally. But I'm trying to understand, why do you place any reliance on this provision in this particular case?
No, I do not. I know it was pleaded in the affidavits, and the department did place reliance on it. But it was, if you read the Immigration Act as a whole, it does require that the Department of Home Affairs facilitate re-entry. And I can only assume that that was the basis for reliance on Section 41. But Section 41 does not apply to South African citizens, and it also makes provision for the person to be in the Republic. So it does not apply, you are correct, it does not apply in Tanzania.
I would like to take you back, I'm sorry about that, the handover of a person and handover of jurisdiction. If you could just clarify to me, explain to me exactly what happened in this particular case.
So, Justice, the handover of a person occurs in deportation because it is to facilitate the expulsion of the person. So Tanzania does not lose custody over the applicant until she exits their territorial jurisdiction. That's when they lose custody and control over her. For example, Justice, if the applicant, after being handed over to the South African officials at the airport, were to have run away, the South African officials would have no authority to pursue her. The deportation order would still stand, and Tanzania would have full authority to pursue her and determine her status in Tanzania. Now, handover of jurisdiction occurs. Handover of a person occurs in deportation because it is to facilitate someone is extradited and an application is made for extradition and the entire process is fulfilled. When the handover occurs, it is a handover of criminal jurisdiction. It is from one authority, one law enforcement authority, to another. Officials at the airport were to have run away, the South African officials would have no authority to pursue her. The deportation order would still stand, and Tanzania would have full authority to pursue her and determine her status in Tanzania. Now, handover of jurisdiction occurs in extradition cases. In extradition cases, when someone is extradited and an application is made for extradition and the entire process is fulfilled, when the handover occurs, it is a handover of criminal jurisdiction. It is from one authority, law enforcement agencies.
according to your case, the handover here, it was from the Tanzanian authorities to the High Commission, and then from the High Commission to Matthewson from the department.
Indeed. And that is handover of a person, not extradition. So it can never be a disguised extradition.
My last question is, what was the basis of sending 2 teams to identify the fugitives and escort them? Why was it necessary to do that?
Certainly from the 6 respondents' perspective, we have a duty. There was 1 delegate in the first team, and that delegate was there to identify the applicant, and that is simply because of the level of subterfuge which had accompanied her escape and the entire criminal activities. The second team was there to escort the applicant and Mr. Thabo Bester back to South Africa. And this is because in normal deportation, one would simply put the individuals on a commercial flight. But in these circumstances, and given the criminal nature of the conduct, there would be, it was not possible to simply put them on a commercial flight and bring them home.
I noticed the notice of prohibited immigrant that was issued to the applicant had a reference that she must be, for her removal, it must be by escort. But the section 25(2)(c) of that act, Tanzanian Immigration Act, makes no mention of anything that has to do with escort. It is silent so far as that is concerned. I don't know. I know it's not our act, but it was just odd that reliance will be placed on this on this provision.
Judge, I'd like to take you to that provision because, and I know it is not our act, and I know that. But just for completeness, if you would permit me, the Section 25(c) says where such person has been declared a prohibited immigrant in Tanzania, he may instead of being brought before magistrate be placed in custody until he boards a ship or aircraft or obtains other means. Now, if we read that with Section 27(4), it says a person against whom a deportation order is made may, if the minister so directs, while awaiting deportation and while being conveyed to a place of departure, be kept in custody, and while so kept shall be deemed to be in lawful custody. And then 6 says that the deportation order shall remain in force. The point you were making was that you were looking for escort, and that is, you will find in the powers given to the general immigration officers in Section 12(1) P, which allows a removal of all prohibited, unwanted, and or desirable immigrants. It does not specifically mention escort, but it does give them the power to. It does not circumscribe their powers.
Just one question. So under what legal prescript did the South African authorities take physical control of Ms. Magudumana at Kilimanjaro Airport?
Justice, can you just repeat that?
Under what legal prescript, under what provision of what law, under what legal entitlement did the South African authorities take physical control?
That would be under the Tanzanian Immigration Act.
So the South African authorities are acting under this Tanzanian legislation. When is that permissible under our constitution?
They are in the territorial jurisdiction of Tanzania.
And they're exercising their obligations as officials of South Africa.
But our law does not apply in Tanzania. It is Tanzanian law that applies, and the handover was done in accordance to the Tanzanian Immigration Act.
Thank you.
Anyone else? Are you in a position to respond to Justice Chick's question, Ms. Mayet?
Yes, the reference is, the question was the reference to the minority judgment. The reference to the minority judgment, it is on case line 00175, and it is paragraph 9.2. The second line, the judge says, if that was the purpose, she could only be legally brought back to South Africa through extradition.
Thank you, Ms. Mayet.
Thank you.
Yes. Thank you. Chief Justice, I have two big points and a few bits and bobs. The first big point is that we agree with our learned colleague for Home Affairs that this wasn't a regular deportation, because in a regular deportation, the people being deported could have been put on a commercial flight. But this involved criminal matters, so they couldn't do it. That's our case. So she's made out a case for us in her submission on that point. She said, this wasn't a regular deportation, therefore those being deported could not be put on a commercial flight. Now my experience, and it's experience, and I don't like to talk from the bar, but as I understand it, in extradition matters, the police from the requesting state arrive at the requested state and they take the people into custody, whether it be a marshal from the US or European, and they escort them all the way from South Africa to that requesting state. Unlike my experience in deportation, I've never heard of a case, never, not out of South Africa, not into South Africa, of people being escorted by the officials from the country to whom the person is sent. That's entirely consistent with the international authorities that my learned friend Mr. Paramusami dealt with. That's the first big point. This was irregular, and our learned friend accepts that. Commercial flights are the order of the day, commercial boats or transport when it comes to regular deportation. Just let me touch upon something that Judge Rogers put to me. Usually what happens is the government of the day writes to the person and says, you failed in your application for a work permit or whatever, the asylum or whatever the thing is, you must now leave within 10 days. And the person leaves or doesn't leave. If they don't leave in South Africa anyway, they get arrested under the immigration laws and there's certain procedures put in place. Never have I heard of a case, and there's no case ever that anybody knows of, where the foreign state involved comes to South Africa to escort the person to that foreign state. There's no such case. And international authorities don't talk to such a provision. That's the first big point. I'll come to the other big point after the bits and bobs. The first bit and bob is this. There's this question of the blindfold, and it doesn't go to the merits entirely, but what it does go to is the notion that my client lied in her founding papers. If one listens to what the police say carefully in their answering affidavit, we didn't blindfold her. But when did they get involved? Remember, the Tanzanians had in custody, and I'll come to the timeline because it becomes important, in Arusha from the 6th of April until the 12th of April, 6 days, and on the 12th of April, the events, the saga happened. She says, I was blindfolded from where I was to when I got to the airport. Effectively, she says that in paragraph 8. The police can't talk to it because they weren't there. So the court can't reject her version that she was blindfolded from the time she left Arusha to get to Kilimanjaro Airport. So on the facts, there's no fact before this court that she wasn't blindfolded during the time. The only blindfolded comment is that the police didn't do it, South African police didn't do it. That's the first bit and bob. The second is, there's a suggestion that there wasn't collusion because the Tanzanians and the South Africans didn't tell the court that there was collusion. No colluding parties will ever tell a court that they colluded. By definition, colluding parties are doing something that they don't want the court to know about. And that's why they make up this stuff about agreements here, agreements there. That's how collusion works. Can you imagine if collusion in criminal matters corruption? The reference says, well, I didn't do it. Of course, that's how it works. That's what collusion's about. The second bit and bob. The third is we agree with Justice Majet's debate, or the comment that he might have made, not that he made any submissions, but the question that he put. It is bizarre that Home Affairs can at this stage come to the court and say there's a violation of their Section 34 rights. Audi. If they had, and they can't point to any prejudice, and importantly, they had an opportunity in the SCA. Remember, the case got to the SCA on what we called petition in the old days. It's now called an application for leave to appeal. I think it's under Section 17. And in this court, they filed an affidavit in this court. And it strengthens the notion that they've had every opportunity to tell the court whatever it wanted concerning not only the so-called amended relief in the reply, paragraph 111, but also what Justice Makhoka found, J.A., found in the SCA. They could have said in the affidavit in this court, well, it's true that there was amended relief, we were prejudiced then, but now let us tell you what really happened. They don't take up the opportunity even in this court. So that strengthens the notion of no prejudice. And it's bizarre that they should say so today. They can't point to it. I come to the big point, Chief Justice, and a difficult point. And my team have debated this up and down, and it arises from a question that, Chief Justice, you put to my learned friend for the police, which is the paragraph 116 of the minority judgment. And it's difficult. I'm not saying it's easy, but I'm going to make a submission on it, which really deals with Justice Collipin and Justice Savage's concerns that they put to me in my debate. The reliefs that would have been granted in paragraph 2.2 of the minority decision talks about no jurisdiction of the trial court. And Justice Collipin says, aren't there other ways in which the police could be disciplined, or the court could show its disapproval of what happened? If this is all on the basis, if you're with me. And Chief Justice, you put to my learned friend for the police, well, what does it mean if there is this notion of no jurisdiction by the trial court? And the question that arises is this, and the minority decision considers it. I abandoned the relief in the SCA, I can't remember whether it was the High Court or I can't remember when I did, that concerned the validity of the arrest warrants that had been issued in this country on the 3rd of April. That would have been paragraph 4 of the original notice of motion. I abandoned that relief. Well, obviously, I did so, and the minority said that I did so quite appropriately, because those arrest warrants were issued before anybody even knew that the applicant and Mr. Bester were in Tanzania. So the arrest warrants stand. The question arises like this. If this court upholds the 2.2 prayer and says the trial court, now the High Court was the Magistrates Court, doesn't have jurisdiction, is that the equivalent, Justice Collip and Justice Savage, of a permanent stay? So that's really what Justice Meyer was putting to me, as I understand, putting to my learned friend for the police. And the answer is this court doesn't have to go into that question. It's a difficult question because, for example, and we can think of many scenarios, this court doesn't know what will happen in the future. And remember, jurisdiction is to be determined at the time the case was brought from Quran, case from long ago of this court. But let's say, for example, and I can't think of many examples, but there must be possible examples. The court upholds it. Dr. Magudumana is released from prison, from the Kroonstad prison where she is now, and a week later she flies to Chile or some other country. The question would arise for the NPA and for the Minister of Justice, could they seek her extradition lawfully from that country? And I don't know the answer, and neither does this court. Because it may well be, Justice Collip and Justice Savage, that it may be that an order of prayer 2.2 isn't the equivalent of a permanent stay in those types of circumstances. I can't think of, and neither, we've tried, we've thought about everything possible, we don't know the answer to the question. And this court doesn't have to answer that question here. It might answer the question if Dr. Magudumana does go to Chile and is an extradition request and she comes before another court, and then we could point to this. So this court can leave open that question, which we would submit satisfies the concerns that Justice Collipin and Justice Savage rightly put to me concerning the balancing. It's not necessarily a permanent stay. And it's a difficult question, Chief Justice and the other justices, but that we would submit would be the full answer to the difficulty of granting somebody who's committed, whether it's minor crimes, serious crimes, the most serious crimes, crimes against humanity, whatever it is. But that's where the real soul, if I can call it that, comes in to soften the distaste that people would leave with if the person is to be freed because of the government acting badly. And when my learned friend says it will be a dark day, where this court it would be a dark day for this court to grant the relief. We submit it would be a dark day when the court, in the face of the evidence that is before this court, on the collusion, on the unlawfulness, we've heard the argument about Section 41, it'll be a dark day when this court reverses all the, what we would call those golden threads, that golden plait that I was talking about this morning, of Muhammad, Matsebe, of all those cases, Makwanyani. That's when the darkness comes, not when the court continues that line of the golden thread. Chief Justice, thank you for allowing me the extra minute. Chief Justice, during the break I gave your clerk 2 books, and let me just tell you what they are so that you don't have to puzzle. The one book is the O'Connell book. It's an old book, not O'Connell, Goodwin Gill. It's a book that Home Affairs relied upon in their late submissions. And that's my personal copy of the book. Have it as long as you like. But what we submit is when
donating it to the Constitutional Court Library. You are not donating it to the Constitutional
I'll donate
Court
the second book. There's a second book. Which, I'll leave that to the Chief Justice. I'll be directed by you whether it's a donation or not. I've just argued a case about donation. There's a Roman principle called gross ingratitude, but we'll talk about it. Anyway, the second book, which is more important, which I do donate, I donate it immediately, is a book called Dugard's International Law, South African Perspective. Now, the book that I've given you is the 6th edition. I'm not going to refer to it or allow myself to refer to it because I'm told that's not the right thing to do, because there's a chapter on extradition, and the book says it prefers the minority decision to the majority decision in this very case. And Dugard's book says the minority is to be preferred over the majority. Now, the reason I can't refer to it is because I contributed to the chapter which said that. It's inappropriate that an advocate should rely on academic authority, which he has been party to in making the submission. But yes, I certainly do, and I don't think the book has come out yet, but I got an advance copy because of my role in the book. Thank you, Chief Justice.
Thank you, Mr. Kurz. The court is grateful for the loan. Justice Rogers?
Mr. Katz, I just wanted to ask on this final aspect of remedy, and you said, well, we don't need to go as to the question whether the effect of finding in your favour is a permanent stay of jurisdiction. That strikes me, if I may say, as a weasel option. any future decision as to whether a criminal court in this country will be precluded from exercising jurisdiction in respect of the charges that you say she has been brought back to face will depend ultimately on what we decide in this case. That will form the basis of the argument. And I don't see why it would make any difference, for example, that she travelled in future to Chile and then was extradited. Well, I don't see why that would be any different from saying, well, she could be arrested in a month's time in South Africa and face the same charges. The fact that she happens to be in another country can't, for the life of me, make any difference. So mustn't we grapple with it? Isn't that the question that this court grappled with in Chilotta? We've got to decide whether the effect of what happened here is such that the applicant should or should not be spared a criminal jurisdiction in respect of the charges that she was brought back to face on your version, and that's assuming we find that that is what happened. It can't become lawful, say, be unlawful in a week's time, but be lawful in a month's time or 6 months' time.
Justice Rogers, you might be absolutely right, but you don't have to decide that now.
Yes, but you don't want us to decide it because you want to be free to argue it for another day. Yeah. It's not going to depend on anything else than what we decide. It's part of the just and equitable relief, exercising the Ibrahim discretion as elaborated upon in Chilotta. If we made that decision in Chilotta, why shouldn't we make it now?
Well, you didn't make it in Chilotta, if you remember correctly, as we understand it, Justice Rogers. What you decided in Chilotta was that the basis of the High Court declining to exercise jurisdiction wasn't properly exercised for the reason that you did, and you sent it back to the High Court. So you haven't decided the issue.
The illegality of the extradition, we said, was not a basis for a court to decline jurisdiction. If we had said the illegality was of such a nature that the High Court should decline jurisdiction, then that would have been the end of the matter, and it would not have had to go back to the High Court to decide other issues. So if in Ms. Chilotta's case she is spared criminal jurisdiction, it will be because of other issues which we weren't concerned with.
I think the High Court's rejected that. Yes. After I've read the judgment.
Yes. Perhaps that's not the last word. But either way, we are concerned with what will be the effects of the illegality if we are with you on the merits. And I don't see why we should defer it. That really is. I'm not saying from your point of view. I think from our point of view, it's a weasel option.
No. I understand. I'm not saying that you should weasel out. I'm not suggesting that. But what I am suggesting, that if you grant 2.2, it may, and it might be a permanent stay, and maybe that's the price that we have to pay, which I've said to Justice Collipin and Justice Savage. It may well be the equivalent of a permanent stay. But you don't have to decide it in this case. It's not a weasel option. Because it might be that case that she goes to Chile and wherever she might go, that she... I understand. You don't have to make it. You find that on the facts as they have been presented, a disguised extradition was made out. What are the just and equitable balancing exercise? No jurisdiction. Can't give the courts. The court shouldn't lend themselves to this kind of illegality. It stops there. That's where we would suggest the court should. But if the court wants to go further and say, well, this is forever and a day for these charges, then the court can do so. But we're not prescribing to the court on that.
I don't think it's a matter of what this court wants to do. It's a question of whether that decision is part of what we have to decide in this case. And on the face of it, to me, it seems it is. You see, there seems to me an important distinction between a case like Ibrahim, where a person is abducted from a country where they are entitled to be and brought to South Africa. It might have been the same in that curious Ciskei case when Ciskei was once regarded as another country. The past is another country, as they say.
As is the future.
Yes. The point there is that if you find in favour of the person that was abducted, they're entitled to go back to that country, and then you would have to go through extradition procedures. In a case like this, Ms. Magudumana, as far as we know, is not entitled to go back to the country from which she, on your version, was taken. She's not entitled to be in Tanzania. So, in a sense, the Ibrahim position can't be recreated.
No, I accept that. I accept that. May I just...
You see, in the Ibrahim case, if the person went back to, I think, from Swaziland in that
Swaziland.
case, if the person had gone back to Swaziland, in principle, South Africa could then have sought Mr. Ibrahim's extradition. You know, it wasn't a permanent stay of prosecution. It just meant he couldn't be tried as an abducted person. He must first be dealt with lawfully. Now, the difficulty here is that Ms. Magudumana can't be back in Tanzania. So the way she would be dealt with lawfully in this country would be, following potentially a decision in your favour in this case, is that she'd be arrested in this country.
With respect, Justice Rogers, you make an important point, which we submit makes my point stronger, and that is this. We don't know whether she'd be allowed back into Tanzania or not. If she applied for a visa, whatever the case is, these are events a different country. And let me just go back to Justice Savage. In answering your question, I just want to pick up on the debate that you raised with me about Ibrahim. Justice Savage put to me, does it make a difference in Ibrahim exercising balance as to the crime that the person committed? And we must remember that the appellate division, when it made its Ibrahim decision, was faced with, and I know that we are now in a different country, but treason, one of the worst crimes ever. But despite that, the appellate division said, nevertheless, no jurisdiction. Even though it was treason, one of the worst crimes known on the statute books. Treason was one of those, this court knows this from the Frankel case, which was one of those cases which didn't have a prescription period on it. Whereas there was the 20-year prescription period, which this court struck down as regards sexual offences. But the proposition that I'm debating or developing is that the worst crimes known to this country at the time, the 70s, treason, when the apartheid government was in a state of war against its own citizens, despite that, the court said, no jurisdiction. The only point that I'm trying to debate, Justice Rogers, it may well be that you're right to say that that would be the end of the line. It may well be. But does the court have to make a pronouncement on that now? And the answer is 116 of the minority decision seems to suggest not. And were the court to be attracted to it, we would have no difficulty with that, and it would somehow fit into the Justice Colopin concern. That's all I'm suggesting.
I'm still not satisfied. I want clarification, especially following from my brother here. Let's go to the orders. In your heads, the order that you sought in paragraph 2.2, no, firstly in paragraph 2.1
of the notice of motion.
No, but you've summarized your orders in your
heads of argument.
Your heads of argument. That's where I am looking at.
Is this on 0061.-2?
No, I'm not looking at it. I'm looking at the paper. Sorry. But I'll read it out to you.
Yes, yes.
You say it is declared that the applicants hand over by the Tanzanian authorities to the officials of the South African High Commission in Tanzania and or officials of the second and sixth respondent and subsequent deportation of the applicant to South Africa were unlawful.
Yes.
That's point number one. That is not my worry.
Yes.
My worry relates to paragraph 2.2.
Yes.
It is declared that the fourth respondent under case number, as well as the Free State,
yes,
that the fourth respondent under case number, blah, 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 as well as the Free State Division of the High Court under case number, lacks jurisdiction to try the applicant.
Yes.
Let's stop there.
Yes.
This is a debate that you had with my brother Rogers now. So if we are with you on prayer 1 and prayer 2,
prayer 2,
prayer 2.2, right?
Yes. Yes.
What? And then the third prayer is the fifth respondent, I think must be the correctional services.
Yes.
Is ordered to forthwith release the applicant from the correctional service
yes.
center. So basically what you're seeking us to do is to, if we are with you, we must confirm the orders that you've asked for.
There are four. There's what it's.
The other one is cost.
Cost, but it's a typo there. It says 4, but it should be 3.
Yeah, it's cost.
Yes, yes. We seek those. Let's call it 4 prayers. Yes.
And what would be the practical effect of these orders?
And that's what I was debating with Justice Rogers.
Yes, that's
I understand. The only answer that I've got is it may be that the prayer 2.2 constitutes a permanent stay. It may be.
Yeah, that's the worry that I have.
That's the worry. No, I understand. It may be. I'm not going to suggest. I cannot suggest that it doesn't. I pick this up on the debate between the Chief Justice and my learned friend for the police, which was a debate concerning paragraph 116 of the minority decision. That's why I've raised the point, only because of that debate. And our team have toed and froed about the point, and we recognize the Justice Rogers' point that the court shouldn't be weasel-like, got to deal with it. I accept that. I understand the proposition.
Yeah, but then how would you want us to deal with it?
By granting it in the same way that the minority dealt with it. And the minority dealt with it by saying, in 116, the DPP can make its decisions in the future, bearing in mind the facts that might arise in the future, the Chile example. There could be consent from the applicant. She could be at 204. It doesn't matter. What matters is that this court, the only point that I'm making, that this court doesn't have to make a final determination.
No, what matters is how is this court's order going to be interpreted and understood. We are not going to give an order that cannot actually be understood. What is the practical implementation and the practical understanding of this order?
If the court...
Let's face it squarely.
Then I'm going to have to, if it's square, head on, then I'm going to have to say, if you don't want to be weasel-like and you have to do it, a permanent stay is warranted under 2.2.
But how can there be a permanent stay when there are pending charges?
No, it's not a permanent stay, but 2.2 of the order that we suggest is that for the crimes that she was deported for, the court has no jurisdiction. That's all, no more than that. It's not a permanent, that's the point that I was debating with Justice Rogers.
But those are the modalities that are very, very important and key for the purpose of this judgment.
I appreciate that. They're very difficult, and I accept that they're very difficult. I accept. It's a difficult issue, but I do believe that Justice Colopin's concern, which we submit is a key concern, and Justice Savage as well, has debated with Chief Justice and the police, cater for the modalities that Justice...
No, but you really have to help us here. You cannot just walk away and leave us to fashion what you would call a just and equitable remedy. Give us the facts. How do we deal with this? It's a source of bother for me, and I think for many South Africans, in the event you are successful.
Yes, no, I appreciate that. I appreciate that. We cannot get away from that. We would suggest that the orders that we've set out in paragraph 2.1, you only get to 2.2 if you go on 2.1, obviously. You only get to the order that in our heads of argument. You only get to 2.2 if you give us 2.1. Without 2.1, we get nothing. But I do believe that Justice Colopin's concern with giving effect to...
No, but if we give you 2.1 and we don't give you the rest, it's a hollow victory.
That's why we submit that from the earliest days of this court, effective relief to the successful applicant is the appropriate justice. It was appropriate because that was under the interim constitution. So under the interim constitution was appropriate relief. Now it's just and equitable. And we would agree.
But in the exercise of a just and equitable remedy, there are considerations that Justice Colopin asked that we should take into account.
We accept that.
Do we let the person free in this cloud of the allegations, or what do we do?
We submit yes. Collusion by the South African authorities and the reference to Section 41, which has no reference, the police going on a high-level multi-department initial investigation with the NPA when fingerprints could have done, the whole pattern. And let me, the 12th of April, the date of the Escort notice, it was timed perfectly with the chartering of the plane. It's all interlinked.
I understand that. I'm not there. I'm here where what the order this court is going to convey to all South Africans.
That when the government acts in the way that it's acted in this case, other facts might lead to different conclusions. The way the government has acted in this case requires a declaration that the courts of this country will not lend itself to a process in which the person appeared before it, was brought before it in the way that is, and the best I can give this court is the dissenting judgment of the US Supreme Court, Justice Stevens, the 3 judges who dissented from the 6 in Alvarez Machine. Because I'm sorry, it's in our heads. But what happened was, it was a Mexican, sorry, I asked the Justice Matoko, the minority decision in Alvarez Machine, judgment of the US Supreme Court, the minority by Justice Stevens, is the kind of considerations that will influence this court's balancing just and equitable relief a la the Schultz-Chilotta line. Because Justice Stevens says, look, even in apartheid South Africa, we don't exercise jurisdiction in these kinds of cases. There was a kidnapping of a Mexican, it was drug enforcement agency issue. And he explains the rationale. Our courts are sacrosanct, they're important. They're part and parcel of our society, they're precious. Our courts are precious, that's what contempt of court. And we don't lend our courts to the government when the government act in a manner that brings the administration of justice into disrepute. And the court will not grant the government that indulgence by allowing the government to use the processes of the court in circumstances when the government has been the lawbreaker the way it's been in this case. So that's why we say 2.2 should be granted. And if it happens, unfortunately, and I say unfortunately, because there's nobody who likes crime not to be investigated, prosecuted, and if found guilty, sentenced. There's nobody.
But you seem to be advocating for the Ibrahim's type of the order.
Yes, very much so. 2.2.
But then we have to look at what offences or charges were brought against Ibrahim and compare them with the charges.
You compare the charges?
I think those charges offended one's sense of dignity, the Ibrahim charges. And these ones, if indeed what those charges are said to be, they have to be viewed with a different lens.
As it pleases the court. As it pleases the court. Yeah.
But when we do that distinction, we view them in a different lens. The question is, where do we arrive at?
No, I understand. So, let me ask you, Justice Matoko, I just want to try and understand the question. When you suggest that the Ibrahim charges bring a sense of violation of dignity.
Sense of outrage. I mean, what Ibrahim was alleged to have done, the majority of the people did not actually consider his conduct to be that reprehensible.
Oh, I see. They consider his conduct to be part and parcel of the struggle. I accept that.
Yes.
No, but the point is that the court, which was on the other side, I don't want to criticize an apartheid court, if there is such a thing. But the courts, despite it not representing the people of the country at that time, and the courts were there, some would say, to give credence to the apartheid laws, but leave aside those types of debates. Nevertheless, in the court's eyes, treason was the worst of its kind. The court, I'm not talking about the people in South Africa at the time, the courts at the time, despite treason being such a bad crime, release the person. The future's another country. That's the point. We don't know how people in the future. At the time, the law was that Ibrahim, he went to Parliament, if I remember, in 1994. But the point is that so he was representative of the people. We know him. I mean, the point is, at the time, the courts had to take the view that what he was charged with, found guilty of, was the most serious crime. That the court had to do, even though the majority of the people who weren't represented might have taken a different view. But from a court perspective, I get into the Uber this morning and the person says, gee, your client, she should go free. It's irrelevant. The point is, that's what the courts took the view of at the time of the treason charges. These charges are serious. Can't get away from that. Not going to say they're not. But as Justice Savage put it, they're not of the most serious kind, such as treason or terrorism or crimes against humanity. So that's a factor that the court will take into account. And I do want to go back to Ibrahim. Treason was as bad as it gets, and yet he got free. That's the proposition that I'm making. And that's something that this court in the golden thread should say, the worst and the weakest. What Sebe did, what Mohammed did, what Makwanyani did, they were appalling.
Mr. Katz, thank you. I'll draw on the wisdom of my colleagues to fashion a remedy.
Thank you. I appreciate the debate. Thank you.
Thank you, Mr. Katz. We spent a lot of time engaging you in an issue that quintessentially falls within our wide discretion. But it's important because this case strikes at the heart of the criminal justice system in South Africa. And while I agree with you that public opinion can never be dispositive of it, but the public interest, I think we all agree, is critical. Ultimately, I don't think we have a choice between whether this case will be a winter case or a bright summer case. Talking about the darkness you speak of and the brightness that you seek. It might be appropriate that this case would be consistent with the season we're in now, an autumn case. It might not be dark, it might not be bright. Well, let me explain to you, Mr. Katz. So, the balance that we seek to strike could be struck in the following way, and I agree with my colleague Justice Rogers, that if we don't deal with that in this judgment and in this order, then we don't provide certainty and clarity. We have all the facts before us, nothing that a future court will not have now. And so we can't duck our responsibility. Secondly, if we don't deal with it now, knowing our appetite for litigation, this matter will be back in this court in 2 years' time, and many of us may not be here, and some may say, well, why didn't this court deal with it in 2026? And it seems to me, with respect, that the solution might be an easy one. That the court expresses itself, if we're with you on the merits, in the strongest and firmest terms about the conduct of the state authorities. However, the court recognizes that the interests of justice are equally important in this matter, and the crimes that the persons in question are accused of, alleged to have committed, require proper investigation and require proper ventilation. That the consequence of an unlawful rendition, if I could call it that, should be halted immediately, and that no proceedings arising out of that act should continue, and they should be regarded as not having occurred and void. However, given that the warrant for the arrest of the applicant still stands, there's nothing preventing the authorities from acting upon that warrant.
In the future?
Well, in the present and in the future. Well, if you know what I mean, it would bring those proceedings to an end. And technically, she could be then released, but there's a valid warrant for arrest. That warrant could be effected, and then new proceedings start, which are not tainted by whatever happened. And in that way, we will have vindicated the rule of law. We would have established a clear principle with regard to how state authorities should act or not act. But at the same time, she will have a day in court, which I think she deserves, and I think South Africa deserves.
Well, Justice Colopin, the only difficulty with these, I'm not sure whether you'd grant 2.2 or not in your scenario, because you made the point. We submit
related differently in the way in which, but I mean that's just my own view. We haven't yet, obviously.
If were to be the case that my client didn't obtain 2.2 in loose language, Justice Matropa's, the court would be failing in its duty to grant effective FOSI relief. And Justice Collipan, what the majority of the SCA, they make the point in paragraph 29, where it says, a court should not be overawed by practical problems. This is from FOSI. They should attempt to synchronize the real world with the ideal construct of constitutional world. And they have a duty to mold an order, and then the important words, an effective relief to those affected by a constitutional breach. And we would submit, in not granting 2.2, in whatever form, you would not be doing justice to the FOSI promise, the constitutional promise. That's our submission.
Thanks, Mr. Katz. I still prefer the gloomy day. Thank you.
Mr. Katz, Ms. Mayet criticized the minority judgment of the SA, suggesting that it misconceived, it labored under a misconception that where a prohibited person is arrested in a foreign country and at the same time is sought by his or her country of origin for criminal-related activities, there is only one manner in which that person can be returned, and it is by the process of extradition. Do you have anything to say about that?
She's made out a case for us. That proposition makes out our case for us.
She criticizes the minority to say that this is a misconception.
Yes, I understand.
Because the fact that a person is sought by his country or her country of origin does not prevent a country where he or she is unlawfully from deporting him or her.
Yes, so my learned friend seems to suggest, if I understand the submission correctly, that where there's a deportation, but that person to be deported is facing criminal charges in their home country, let's say. Yes. The only way to deport the person is to the home country. That's how I understood the submission. And the minority...
She criticized the minority for holding that position.
Yes.
Yes.
No, the minority held the other way around, if we understand it. The minority held that where there's a deportation and the person is sought for criminal charges, that doesn't mean that the person must be sent back to that country. That's what the minority held.
And if I look at paragraph 74 of the minority, page 346 of the hard copy record.
I have it, yeah.
It says the appellant was lawfully arrested and detained by the Tanzanian authorities because she was in that country illegally.
Yes.
And then it continues, but she was also a fugitive from justice in South Africa.
Yes.
Then it continues, the legal mechanism through which a fugitive from justice can be handed over to the state which seeks her or his prosecution is through extradition.
Yes.
So I understand that to mean that she could not be deported but could only return through extradition. I think that was a criticism. So I want to hear you on that.
Our submission is this. When somebody is deported, it's destination neutral. So if she had the right or
Maybe before you get to that, don't you read that paragraph to say that she could only be returned by way of extradition?
To South Africa to face charges, yes, but not deported. This is what the minority say. So the minority says, if she's to be handed over to the South Africans, the only way they could do it would be through extradition. That's what paragraph 74 seems to suggest.
All right. Now, if you disagree with that, she has referred us to two international authorities. Is there any authority that you can refer us to say that this is not the only mechanism by which a wanted person can be returned who is in a country unlawfully? Are you able to assist us in that regard?
Yes, I understand Justice Majid to have dealt with the issue. He said, well, either you have extradition or you have deportation. And he said there may be some other ways, but leave aside the other ways. Our submission is very simple. Either there's an extradition to the country to where the person's facing charges, extradition, SADC protocol in line with the Tanzanian extradition laws. If it's a deportation, the destination and the notion that the person is a fugitive is irrelevant to what happens to the person. As long as the person leaves the territory of Tanzania, that's the end of it. And to the extent that the fugitivity, if I can call it that, is to play any role in the deportation process, it makes out our case. The deportation must be fugitive neutral. The purpose of deportation is to rid the country of the foreigner, the illegal foreigner. It's not to assist the country which wants to prosecute the person. And as soon as there is that taint in the deportation process, we're in the world of disguised extradition. The Tanzanian authorities had to be blind, deaf and dumb to the fugitivity issue in this case in its deportation process. And as soon as it wasn't deaf, dumb and blind and it took it into account, we've crossed over.
But one of the authorities that we are referred to suggests that I'll just read from the 6th respondent's heads.
From the 6th respondent's heads?
Yes, it's the Canada Minister of Employment and Immigration, where it says, I see nothing inherently unfair in a foreign state delaying extradition proceedings when it is known that the individual in question is likely to be deported in any event. So I think the point being made there is that there's nothing wrong with South Africa delaying making a decision to commence with extradition proceedings where this person is held in a foreign country where she may be declared a prohibited immigrant and may be liable to deportation.
My Lord, Justice Nuku, apologize. The question I think that you're posing to me was dealt with Mr. Puramulsamy in full. Chief Justice, I've used up more than enough time. My voice, you heard my voice. May I ask Mr. Puramulsamy to deal with it because I believe that he dealt with the question in full, and I don't want to repeat.
I just want if there's any authority that would gainsay that. I think that's all the assistance I need. I don't need the...
Yes, Mr. Puramulsamy has those authorities. I think he mentioned them.
Oh.
He did mention them. So may I ask Chief Justice?
As long as someone answers the question.
Yes, he will. He will. He promises me that.
Chief Justice, Justice Nuku, could I just explain how this comes about? Because it is a little bit important. I promise to only be 2 minutes on it. In the specific case that you refer to, the person there was challenging a deportation order. So they had an opportunity to leave. They didn't leave. They challenged it. And then there was arrangements that were made after the challenge was unsuccessful for the person to be deported. Now, in those instances, you look at where the country of destination is, where the person has been unsuccessful in their deportation. Then there was arrangements that were made after the challenge was unsuccessful for the person to be deported. Now, in those instances, you look at where the country of destination is, where the person has been unsuccessful in their deportation challenge. That's the answer. So the first, for all deportations, the first port of call is that the person gets to leave. They depart because you have no interest in them being there. But if they refuse to leave, and if they challenge their deportation order, then you can deport them and say, you must go to your country of destination, which may include your country of origin, but it may also be a totally different country.
Last question I wanted to ask, Mr. Katz, you had indicated when you were making submissions earlier on that that agreement declared a prohibited immigrant. If you look at paragraph 83, second sentence reads, an agreement was reached at the South African High Commission in Tanzania for the deportation of the appellant after she had been declared a prohibited immigrant by Tanzanian authorities.
No, Nuku, that's what...
I'm reading the judgment.
No. What the judgment there describes in the second part of paragraph 83 is the argument that Home Affairs made. Because if you see in the top, in a nutshell, the Minister of Home Affairs contended as follows, and then there's a certain number of sentences. So what the minority was describing what Home Affairs were arguing. He wasn't saying what the true facts are. But the true facts are to be found on the papers, which is inconsistent with what the minority described, the way Home Affairs described the argument to the... Well, Home Affairs weren't at the SCA. They made no submission to the SCA, so they weren't there. But the point is here, it says they contended as follows. An agreement was reached at the Commission for the deportation after she'd been declared. That's what they...
In other words, that's their version.
That's their version. That's their version. That's
Yes.
their version, but on the facts, that version is incorrect. On the true facts, as I pointed out in paragraphs 10 compared with paragraph 13 of Ms. Morong's affidavit, those facts are not true.
Thank you, Mr. Katz.
Sorry, Mr. Katz, I don't have a question, just to comment. In your remarks, you said that the Tanzanian authorities must have been deaf, dumb, or blind. I'm not sure if those remarks are appropriate in the Apex Court or anywhere in any court, because it suggests that people who are deaf, dumb, well, I'm not even sure dumb is appropriate, somehow function at a different level and are entitled to less guarantees of equality. I don't think you intended that, but
No, I apologize if I meant, what I meant was this, and the point is this. Perhaps a different word would be...
I know what you tried to say.
No, but just to apologize to myself. I accept what you say.
Thank you.
What I meant was they were agnostic. Well, this is what I said. The Tanzanian authorities, in exercising under international law a deportation, were required to be agnostic as to the destination when it comes to fugitivity. And I do apologize for using words which could malign those who are disabled or otherwise. But the proposition is agnostic is the better way of saying it.
Thank you.
Thank you. We've reached the end of the road, Mr. Katz. Thank you for your submissions. Thank you, everyone. Judgment is reserved.
As President.
Just an equitable remedy. That's what you say, correct?
No, I'm not sure.
Okay, let me read it, because then it says jurisdiction is a binary concept at paragraph 114. A court either has it or does not. The court cannot create jurisdiction through its equitable remedial powers. This has been confirmed by this court in social justice. Right. So I have a difficulty with that. Well, I might mention that I was alone in social justice coalition on the other side. But I think what you do with respect is you confuse jurisdiction at the outset and in the way in which it's used here. You urge the court to find that we have jurisdiction to entertain this application, which we must, if we're with you. No. If we follow that, then if we find that the conduct of the state parties is inconsistent with the Constitution, then surely Section 172(1)(b) gives us the jurisdiction in wide and untrammeled terms, subject only to the considerations of justice and equity. Do you accept that?
I must accept that.
Okay. If you accept that, then going back to your formulation of your three threads, the weakest and the worst amongst us, we shouldn't condone state law-breaking, and we should be careful not to yield to public opinion.
Yes.
I want to put this to you. In Cholota, this court spoke about, even though there the court had found that the extradition was unlawful, the court spoke about the need to balance lawful process with impunity, and did not find that it was appropriate for the Free State Court to find that it could not exercise its jurisdiction. Under those circumstances, this case is distinguishable from Ibrahim. In Ibrahim, Mr. Ibrahim was lawfully residing in Eswatini. He was abducted, and the High Court was asked to accept a version from the state that the police colonel was sitting in his office minding his own business, and in walks Mr. Ibrahim, who says, "I believe you might be looking for me." And the court rejected that. Here we must accept that your client was in the lawful custody of the Tanzanian authorities. Right. On what you said in response to earlier questions, there was a series of handovers. And one could say that was unlawful, but it's a far cry from an operation in the middle of the night to bring her back to South Africa.
I accept that.
Under those circumstances, how should one then balance lawful process with impunity, given that, and I accept that we don't yield to public opinion, but the public interest is a different matter. The public interest in ensuring that we have an effective system of the administration of justice, the interest involved here would be the interest of your client, but there would equally be involved the interest of state witnesses in any prosecution she might face with regard to the serious charges that she must face. And it would involve the interests of the greater South African public in ensuring that there isn't impunity. Under those circumstances, would you still insist that even if we find that the conduct of the state officials was unlawful, that a South African court should not?
Yes.
Because that wouldn't be condoning that. This court could, in the strongest terms, express its view and set its face firmly against that conduct. It would potentially give it a claim for damages, I don't know. But on your version, if she was to be extradited, she would have to spend time in a Tanzanian court waiting extradition proceedings, but that's neither here nor there. So that's my question, Mr.
No, I understand the question. Let me go back to your premise of the question. I think it's quite an important dialogue that we would have. Your dissenting judgment in Social Justice Coalition disagreed with the notion of the binary concept of jurisdiction for the reasons that you articulated. And it happens to be that Mr. Perumal-Sami and I were in the Schultz-Chilotto case, but not in the Chilotto part of the case. And this court found, and it's not entirely, well, let me put it this way, it found that jurisdiction wasn't binary for the reasons that were articulated by Toronje in the context of the Chilotto extradition. In our part of the case, that issue fell away, but it didn't arise for the reasons that the court knows. But what Toronje did do for the whole court was to say that the balancing of impunity must be balanced, and she refers to Latif and Horseferry Road for this, with the notion that the administration of justice must not be brought into disrepute. And those are the words that we submit this court should focus on if the court gets to it on the basis of a disguised extradition. And the question is this, and all the cases say, Horseferry Road says it clearly, a court in South Africa should not lend its process in the context of the administration of justice when there's been the kind of conduct that we would submit is to be found here. And that's the real test. Yes, impunity is something that we all accept as a general proposition. Those who are alleged to have done criminal acts should be tried. We accept that. But not in circumstances when bringing them to court in the manner of a handover, disguised, nefarious, charade, ruse, that would bring that type of conduct, and the use of state machinery, the courts, would bring the administration of justice into. Just let me say the third thread. I think you described it as public opinion. The third thread was public opinion, but it was also this question of that's the price we pay for living in a society where the rule of law is that thread. And that's what was said in Tsebe, because Tsebe, I presume, would have received impunity because of the price that we as a society have chosen to walk a particular path, and that is a rule of law path. It's unfortunate. Nobody likes it.
Okay. But sorry, Mr. Katz, just two quick questions on that. Would you accept on the first one that this is not an Ibrahim type of case, nor is it a Chilotto case? It may be somewhere in between. And that ultimately this court must make a value judgment with regard to the agrarianness of the conduct and the degree to which it does not conform to what, and determine a just and equitable remedy on that basis. And that's within this court's wide discretion. Then, arising out of that, I think we need to be careful about the price we have to pay, because the price it's not an all or nothing. A court can equally be clear and firm about the need for the state to conform its conduct to the highest standards of legality and constitutionality. And it can do so in a manner that strikes the appropriate balance. In some cases it may not be possible, where the court might be obliged to say, well, you should not exercise jurisdiction because the agrarianness of the conduct is such that if you do so, it will bring the system into disrepute. But we must make the call whether in this case that would be the outcome. And that's a call for the court to make.
It would be difficult to disagree with the ideas that Justice Colopin, you put to me. But we would suggest that although Ibrahim might be somewhat on the spectrum of the kind of egregiousness of conduct, this case is very close to it. And your Justice Colopin, you put to me,
why do you say it's close to that? Because you're saying that there was an agreement on deportation. So there was an attempt, there was at least a purported attempt to bring their conduct within the law, even if it was misguided.
No.
There was an agreement, you say.
The exact opposite. No, that agreement was unlawful in terms. It was a ruse. It was a charade. There is no agreement in deportation. And they knew. It wasn't that they didn't know. If they made a mistake, a bona fide mistake, a la Charlotta, then one would have to accept that the 172, 1B, just an equitable debate, would have some meaning, but not in a case like this. This was a ruse from start to finish. They had no power being there.
I'm not sure if the evidence supports that, but anyway, Mr. Katz, maybe we leave it at that.
Well, Justice Colopin, let me ask this question rhetorically. And this is what the minority put in the, on the paragraph that I wrote. Why did the police go there in the first instance? Where did they get the power to do it, firstly? But let's assume they had the power, a power that doesn't exist. Why were they there? They were there to achieve to find that there were people who the police wanted to prosecute. That's why they went. Start to finish. And the Tanzanians said to the South African delegation, are you going to send an extradition request? And the South Africans responded, what do you say? That's not the conduct of a state which should be able to use the machinery of the courts to do the necessary issue of prosecuting persons. The South Africans from day one behaved in a fashion which undermines the rule of law 101. And this case we would suggest is like Horseferry. There wasn't the Ibrahim type conduct that one's in Horseferry with Bennett, which this court quoted with approval in the context of a disguised extradition. There, the House of Lords found that let's call it the collusion between the various parties, South African government, British government, rendered the conduct of the government such that the English court should not exercise jurisdiction. Very similar to here. Well, ours is worse, actually. But that's not the point. You don't have to get to Ibrahim to be able to find the no jurisdiction line, in our view.
I've heard you. Thanks, Mr. Katz. Maybe we might take different views on the matter.
Mr. Katz, I wish to direct you to certain passages in the majority judgment of the SCA. These passages talks to the pleadings. I start with, it's paragraph 16, where the SCA describe what the issues were before them. And Roman figure 1, in paragraph 16, it says, was the appellant arrested in Tanzania by members of SAPS or Tanzanian authorities? And in paragraph 21, the SCA seems to answer that question. It says, since the appellant was seeking final relief in the matter, in terms of the Pascon-Evans rules, this had to be decided on the minister's version. In other words, the minister had denied that she was arrested by members of the police. And the SCA says, this evidence shows clearly that the SAPS did not take any action against the appellant until her arrest in Lanseria. So what I want to posit there is what you had just alluded to, and when you were discussing with my brother Kolapenje. If SAPS, or what was the role, if any, of SAPS, going all the way from South Africa to Tanzania? And was it merely to escort? And if so, escort who? And if SAPS had not gone to Tanzania, does it mean that whoever or whatever, or the persons who had to go there, they couldn't do what they had to do, absence SAPS?
Just the interesting position of not knowing whether your question is one that sort of leads to a favorable decision for my client. Is it against me or for me?
I'm just exploring it. I'm just testing the
But
proposition.
I want to answer it like this, which is in our view an incorrect summation in paragraph 21, as you put it. They say that it had to be decided on the Minister of Police's version, since his evidence shows clearly that, and then there's what the evidence shows. We accept Lascon evidence. But then he says, did not take any action. That's not true. We reject that in the firmest of terms. For a policeman to stand next to a Home Affairs official or next to a High Commission official to witness, to secure the handover, is taking action in Tanzania. It can hardly be suggested that police presence in Tanzania, when somebody is handed over and the police witness the handover and they're there to protect the people who are being the recipients of the handover, that is by definition action.
Can I put it differently? If something wrong were to happen to the suspects and the police are there, would not liability arise by way of omission? Because police are there.
That would, well, I'd rather
police
ask,
are there.
No.
Minister says police did not take any action. They were just escorting the people there.
Escorting.
I'm putting it differently. If, for argument's sake, something different had happened and the police are there and we know the police duties to protect and they did not protect, would they not attract liability on the basis of omission?
I would have thought not. But more importantly, we would ask a different question, and this is the real question. If Bester had attacked Matthews, would the police have had any power to do anything?
That's what I've put to you. But
that's the real question. The real question is, what could they do if Bester did what was threatened, that he was a dangerous man and Mr. Matthews needed protection, so he brought the police along? It's not acceptable. It's not acceptable. It's not lawful. It's as simple as that. But that's why I say that it cannot be suggested that because no incident arose, it is suggested that they did not take any action. It just, well, then it goes on, this next sentence, the version put forward on behalf of the police and others could not be said to be far-fetched or clearly untenable. The version of the police is that members of the SAPS were not involved in her arrest or her removal, but they were. They were there. They were involved. I accept that they weren't involved in her arrest necessarily, but her removal, they certainly were involved.
Let's go to the pleadings, the structure of the pleadings.
The pleadings, a paragraph?
The pleadings, no. We just get into the pleadings in broad terms. We have the notice of motion, which did not cite the sixth respondent. The notice of motion made averments, general averments, right? You would say, and the minority said, in the notice of motion, if you read the founding affidavit, allegations about disguised extraditions are there. And then you go to the replying affidavit. The replying affidavit, for lack of a better word, sought to improve what was stated in the founding, taking into account the answer. Right?
It was more focused because of the answer.
Yes. Now, that's how pleadings are supposed to be considered.
Yes.
If, as the minority says, the the respondents cannot claim that there is a new matter because it was foreshadowed, 1, in the founding affidavit, 2, in the reply as a result of the response in the answer. Therefore, this was consistent with the pleaded case that was before the High Court.
And that's the argument.
The SCA, as I understand the majority judgment, just decided the case on a narrow point. To say, you did not plead. Because you did not plead, it's a new matter. And because it's a new matter, you could not expect the Department of Home Affairs or the other state respondents to respond to the new matter. They were prejudiced. Therefore, rules of the pleading says you are confined to the 4 corners of the pleadings. Absent that, you out. But the minority adopts a different view. It is that view that brought us here.
That's right.
And it is that view that I want to interrogate with you.
Well, we would say that the view of the majority, which we submit was an inappropriate view, is what really brought us here. Because if there had been 5 judges, or the other 4 judges that signed on to the minority, we might not be here. We're here because of the 4, rather than the 1. The 1 got it right, in our view, in our submission. The 4 got it wrong. And that's why we're here.
In the minority judgment, there is some reference being made to, I think it's a fallback position if I were to describe it that way, that the point about the disguised extradition may be considered to be a point of law, and if it's a point of law, and if it's foreshadowed in the pleadings, it can be raised at any time. Would that be a proper finding?
Yes,
is that a point of law?
We argue that it is, yes. We argued it in the SCA. We said that if one looks at the facts as presented, the facts, the legal consequences of those facts, that this is a disguised extradition. And it's a term of art. Even if, let me say Justice Matofo, even if the words disguised extradition had not been in the replying affidavit, it would have still been open for us to argue that this was a disguised extradition. In the same way that I know that Justice Collipin distinguishes it perhaps, but Botha versus Smuts, these are terms of art, legal terms of art. If the evidence shows that the government used a deportation to achieve an extradition, that's what the evidence shows. And there's nowhere in the evidence the words disguised extradition don't appear in that form, in express terms in the pleadings. It's perfectly legitimate for us to argue this was a disguised extradition, if that's what the evidence shows, and the evidence does show it here in our submission.
I know you do a lot of these cases, but there are certain facts that troubled me, and one is the one that we've just traversed on disguised extradition. If one were to say, and the authorities in Tanzania were fully alert about how a suspect has to be transited to their country by virtue of the fact that they did ask the South African authorities, you are here, are you going to commence with your extradition processes? And the South African authorities say, no, we're not. But do people get handed over in the circumstances that the applicant and Thabo Bester?
I want to answer it in 2 ways, Justice Matopo. The South Africans did not say no, we're not. They said they would be guided by what the Tanzanians agreed to. So they never said they wouldn't. If the Tanzanians had said, bring an extradition, they would have had to bring it. Number 1. Number 2, your question, which is a key question, as we understand it, is what happened here a regular deportation under Tanzanian law? Now, I know and I accept that this court cannot or shouldn't venture into the question of, did a foreign government act lawfully in terms of its law in that country. Because this court is only concerned with the conduct of the South African government. And there's the doctrine of the act of state, which suggests that this South African court should not consider the validity of conduct by a foreign state in that.
Well, put it differently. Did the South African authorities act lawfully by traveling to Tanzania to collect the applicants?
Well, they didn't act lawfully in three senses. One, they didn't act lawfully in the international law sense. There's no international law provision made for that. Two, they didn't act lawfully in terms of the Constitution. Three, they didn't act lawfully in terms of any legal provision. There's no legal provision that allows for what they did that we know of. And the only one that's pointed to is Section 41. And Section 41 doesn't talk to any of this kind of conduct. So we would submit that on any level, this is the kind of unlawfulness that is staring the court in the face. But leave aside that for a moment, and that's clear. So if one talks to Justice Colopin's debate, and said, well, this was unlawfulness, they thought they could go under Section 41, but they couldn't, a Charlotta type situation, then one could understand the debate that Justice Colopin and I were having about remedy. But this isn't one of those cases. This was collusion, it was a charade, the entire saga was in order to achieve that which could not be achieved under the immigration laws of Tanzania. And if one has regard to what the South Africans say, Tanzania relied upon Section 25(2)(c) of the Immigration Act in Tanzania, which Justice Makhoka does deal with, the minority does deal with. This isn't one of those cases. 25(2)(c) has got nothing to do with the case at hand. 25(2)(c) is a case where, but I know that this court isn't geared towards answering questions about Tanzanian immigration laws and statutes. But if the court, and Justice, the minority did consider it in some respect, but if one considers the provisions of the section which is quoted by SAPS, doesn't do what they say it does, the Tanzanian law.
Let me finish. If we look at the four corners of the appellant's pleaded case, do we find that, without attaching any label, because it looks to me that we should be careful not to be putting unnecessary labels, because if you put labels, that's where you go wrong. If substantively, on the four corners, there is a case made out that, one, there was a disguise, whatever we call it. I don't want to say deportation or extradition.
Well, an unlawful removal and handover.
Unlawful removal and handover. Then a party in the position of the respondents, one would ask, do you know what case you are to meet? If they do, are you prejudiced because no label has been attached? Absent the label, is there a case that you know that you are to meet?
Absolutely. That's the question. And if one looks at the founding affidavit, one looks at I've read it to the court, Pred 2 of the notice of motion, that case is square, it's there. South Africa removed the applicant from Tanzania, assisted in the removal of the applicant from Tanzania to South Africa, founding paper, Pred 2. There are add-ons to that, which the court can ignore, such as the original arrest, which SAPS have given a full answer to, but not the removal. The answer to the removal is it was unlawful.
Would the fact that there was no cross-appeal be a flaw in the judgment of the majority when it dealt with it? Be a flaw, constitute a flaw?
Yes, we would suggest so. Well, that minority points it out.
Minority deals with it.
The minority says that it was a flaw. It says so. And let me just say, you know, what struck me in preparing, how much time, unusually, and I say it was unusual in a certain sense, in the minority starts on paragraph 43 of the judgment. There are 3 paragraphs, 44, 45, 46, and 47, 4 paragraphs, which set out in broad summary why there was a flaw in the pleadings finding by the majority. So just 4 paragraphs as a summary. And then all the way from paragraph 48, all the way through, and it's a long, long debate, up to paragraph 68, where the minority explains in detail, thorough, considered, with reference to this court's judgments in many cases, why there was a flaw in the majority's thinking. From Barkhuizen to Pretoria Port and Cement to Justice Collipin and Justice Chaskelson AJ in Botha versus Smuts, all of the cases that this court has referred to over and over and over in the pleadings context, the minority deals with. Hanekom versus Neverkloof private game. There are many. I mean, it's too many to mention. But there is a thorough and full judgment on why the majority were flawed. If one looks at paragraph 31, there are 8 cases dealing with this question of what you put to me, Justice Matopo, about the question of prejudice. Would the respondents have framed their answer in any different way had it been pleaded differently? The answers given in 650 or 40, all through there, 52, 62, 63. And then they say, and then the important point, they even alternative, Justice Matopo. Even if the disguised extradition point constitutes a new case in reply, is it a point of law which can be advanced, even if not specifically mentioned in the papers, and the point that you make, Justice Matopo, A, if it arises from the facts, and B, no prejudice. Because there's no suggestion of prejudice. And let me go further. When it's a question of prejudice, we note a lot of talk about prejudice in the heads of argument by Home Affairs, by SAPS. But they've had every opportunity along the way to put facts which cures the prejudice.
All right. Before I step aside, I don't want to hog the space. It's a point that has been raised, that the appellant, or the applicant rather, did not join the Department of Home Affairs. Is that fatal to the applicant's case?
Is it?
Is that fatal to the applicant's case?
Fatal? No, not at all. The applicant believed Home Affairs played no role in the saga. Until Home Affairs comes along and says, we did play a role, and this is the role we played. Now you've told us what role you played. Unlawful disguised extradition. How can it be fatal to the...
Is it somewhere in the papers that the applicant was aware that in Tanzania, the crew that brought her, I don't want to say arrest, because arrest is the problem now. The crew that brought her back to South Africa included officials from the Home Affairs?
No, she didn't know. She only knew because of what he said in the answering affidavit.
She thought these were police officers.
That's what she said. That's what she said. I think she also at some point thought that there could be the defense. She didn't know.
Sorry, I missed that.
There was some point, if I remember correctly, where there was a mention that it could have been SANDF.
Oh yes.
But it's irrelevant. She didn't believe that Home Affairs were part of part of the crew. It turns out they were part of the crew. They were the dominant feature in the crew. And bearing that in mind, they were joined. They filed an answering affidavit. There was a reply. And in the reply...
Help me with the order. I know there was a request for information. Did it come before the papers were drawn or...
Before.
Before the papers were drawn. And that request was declined?
It was suggested that the applicant makes use of PIA. That was suggested. One sees that, pages 32 and following, where the attorney wrote to say, our client is pending trial, our client was arrested, we hold instructions to demand the following, the process and procedures, and then the state attorney writes back to say, well, I'm not sure it's the state attorney, but there's a write back from the DPP on page 37. I'm directed by the DPP to acknowledge receipt of the request. And then it says, despite the undermentioned unclarity, she was arrested at Tanzania, and any further information must be sought through PIA.
Thank you.
Mr. Katz, I just want to concentrate for the moment on what Tanzania as a state did in this case. your client was illegally in Tanzania. Those are the facts.
Yes.